Subcommittee, and we're all members of the Corporations, Elections, and Political Subdivisions Committee. And we formed a subcommittee to come over here and have a hearing with you guys. So let's start by calling the roll. Thank you, Heather.
Senator Boner.
He's excused. My understanding he'll be here shortly.
Senator Steinmetz. Here. Representative Johnson.
Present.
Johnson? He's definitely present.
Representative Weber. Here. Co-Chairman Knapp.
Here.
Co-Chairman Case.
Present. Thank you very much. So everybody, my name's Cale Case. I am from over in the center part of the state. I'm from Lander, but my daughter-in-law is from Newcastle, and she's a very nice person. I will say that. And my family homesteaded down at Lost Springs. That's where my grandparents were. So would anybody else like to introduce themselves? I know you know some of these characters, but let's go to my co-chairman.
I'm Representative Knapp. I'm from District 53, which is over in Gillette.
Hello, everybody. I'm so happy to be here. I am Nina Weber, representing House District 24 in Cody, and I can tell you it is a long way to this side of the state. Anyway, beautiful drive, nice little town, and I saw so many antelope jumping around being really stupid.
Well, hello, everyone. I think you know me, but I'm Senator Steinmetz, and I represent this part of the southern part of Weston County and Goshen and Niobrara. So it's good to see so many of you here, and my colleague, Representative Williams, who we ran this bill together, and also our speaker, Representative Nyman, is here, and yay! Senator Boner made it through road construction. So I was only a little ways ahead of him, so we all made it. And we're glad to be here, and I think we're introducing ourselves, Senator Boner.
Well, just in time. Great to be here. Sorry I was a little late, but you know, I was busy sorting sheep, and then had some road construction come up here. So yeah, good to be here. Certainly was on this committee last time we did redistricting, and looking forward to hearing the perspectives and concerns that we have in this community. And so, yeah, thanks for hosting us. I'm glad to be here.
And then let's go online to Representative Johnson.
Thank you, Mr. Chairman. I'm Steve Johnson, representing House District 8, and I'm in the South Dakota on a pheasant trip that we'd planned before we scheduled this meeting. So I'm zooming in to help everybody in my district, and let's do the right job. Thank you.
You shouldn't have gone over there. I passed about 30 pheasants on the way over. Let's hear from our staff. Mr. Obrick, would you introduce yourself?
I'm Matt Obrick. I work for the Legislative Service Office in Cheyenne.
Hi, I'm Heather Hunter, and I work for the LSO in Cheyenne.
Yeah. So Mr. Obrick is being very understated. He's the director of the Legislative Service Office, and he came up through the ranks. And in fact, he staffed the Corporations Committee, Corporations, Elections, and Political Subdivision, and we've been through redistricting efforts together on many occasions. And I specifically asked that he come and help us to work through all this. So the reason that we're here is because in the last session of the legislature, there was a bill passed called Constitutional Apportionment. It was actually Constitutional Apportionment 2. It was carried by Senators Driscoll, Cooper, Dockstader, Hicks, and Larson and Steinmetz, and then also by Representative Wharf and J.D. Williams here. So the bill provides that the legislature should take some time to come over here and listen to you, basically, and to listen to your concerns about representation and redistricting. And so I think, you know, that's the reason we're here. It has, the bill does have some specific findings, and I don't know if, Mr. Obrick, if you want to lead us through that at all, just to make sure we touch all bases.
You bet, Mr. Chairman. So the first item after your agenda and your packet of materials is Senate File 174, being Senate Enrolled Act 73. And Mr. Chairman, as you mentioned, Section 1 of the bill starts with findings. The people of Wyoming did ordain and establish the Wyoming Constitution. The Wyoming Legislature derives its powers from the Constitution, and its acts must be conformable to it. Article 20, Section 1 of the Constitution provides that the Constitution may be amended and specifies in what manner. Onto page 2 at the top, subsection 4 provides that the apportionment provisions of the Wyoming Constitution are quite clear, citing to a Wyoming Supreme Court case. Paragraph 5 provides Article 3, Section 3 of the Wyoming Constitution. Each county shall constitute a senatorial and representative district. The Senate and House of Representatives shall be composed of members elected by the legal voters of the counties respectively. Every 2 years, they shall be apportioned among the said counties as nearly as may be according to the number of their inhabitants. Each county shall have at least one senator and one representative, but at no time shall the number of members of the House of Representatives be less than twice nor greater than 3 times the number of members of the Senate. Paragraph 6 quotes Article 3, Section 48. At the first budget session of the legislature following the federal census, the legislature shall reapportion its membership based upon that census. Notwithstanding any other provision of this article, any bill to apportion the legislature may be introduced in a budget session in the same manner as in a general session. What that last sentence or provision provides is that it doesn't need the 2/3 introductory vote. On the top of page 3, paragraph 7 says, since 1992, the Wyoming legislature, contrary to the Wyoming Constitution's apportionment provisions, has allowed for the creation of legislative districts that do not follow county lines and legislative districts that do not have at least one representative and one senator per county. Apportionment for the Wyoming legislature must also conform with the Equal Protection Clause of the 14th Amendment, under which the overriding objective is that the vote of any citizen is approximately equal in weight to that of any other citizen in the state. Paragraph 9, conformance to both the federal and state constitutions may be best achieved with a legislature of manageable size. 10, no inconsistency exists between the requirements of Article 3, Sections 3 and 48 of the Wyoming Constitution and of the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. And the Wyoming legislature must comply with both constitutions in apportioning for legislative elections. Section 2, the legislature finds that the legislature shall make a good faith effort to apportion itself as required by the 14th Amendment in conformance with the principle that a vote of any citizen is approximately equal in weight to that of any other citizen in the state. And the legislature shall make a good faith effort to apportion itself as required by Article 3, Section 3 and 48 of the Wyoming Constitution by providing for legislative districts that follow county lines and legislative districts that have at least one representative and one senator per county. Section 3 is how you all got here today. The Management Council of the Wyoming Legislature shall assign a committee of the legislature to study apportionment of the legislature as provided by this act during the 2025 interim. The assigned committee shall conduct meetings in communities around the state to take input on apportionment options from members of the public and other interested stakeholders and report its findings to the legislature no later than December 1, 2025. The committee, and probably that means the full joint corporations committee or management council, may introduce legislation to constitutionally apportion the legislature for introduction in the 2026 budget session.
Thank you very much, Mr. Director. Any questions for the director at this point? I do appreciate that. Thank you very much. So my understanding is that we have public comment online at this point. I understand that Secretary of State Gray wishes to make public comment, and then there's another gentleman online. You think he's there? Okay.
No.
Hi, Mr. Secretary. Welcome.
Yes, thank you. Appreciate it. Just for the record here, I am pulled over. My plan was to comment as the meeting progressed, Mr. Chairman. I do have some prepared comments, but I wanted to go through the agenda and had some comments once we saw the different proposals. I didn't really have any comment on the enabling legislation.
Fair enough. We had you listed, but we have you listed in both places. So if there's no questions for Mr. Secretary at this time, hang tight and we'll follow up with you a little bit later.
Thank
And
you.
how about is Mr. Correnti? Is he online? Okay. He looks a lot like Representative Johnson, actually.
It must be twin.
So
Mr.
many.
Correnti, go
Thank-
ahead.
Thank you, Mr. Chairman. It's kind of in the same posture as Secretary Gray. I didn't think I'd be speaking till later, but I do have comments that I can contribute now, and then I'll send you guys written notes if necessary. But I've looked over all the materials. First of all, I'm Joey Correnti, a former chairman of the Carbon County Republican Party, also the former chairman of the Wyoming Republican Redistricting Committee, and I've been either observing or involved in redistricting for the past 2 cycles since 2012. When I did look over the meeting materials, I really didn't find myself being in favor or against any given proposal that was presented, but I did have several concerns that are more procedural or constitutional related. Firstly, the posture that kind of brings us here, I agree with. Our state constitution says one thing and we have a footnote that has us doing something else. But the sentiment I've gotten is the posture of the county integrity within legislative districts being concerning. And it's definitely a legitimate concern amongst the people recognized in the Wyoming Constitution. But what I see happening is it presenting a potential eventuality of revisitation of all the efforts we're currently engaged in once county-specific districts are potentially established. And then we get the flood of community interest complaints that come after that. I could see in pretty short order the posture of our county voice isn't represented by the current process because of the population density in another county within our district, pretty quickly evolving into our community voice isn't represented by the current process because of the population density in another community within our own county. So I think what we really need is a really holistic, comprehensive idea of the postures, the constitutional provisions. I'm not going to get into a lot of the court decisions, but I do know that we have some Wyoming Constitution specific focuses that probably need to be addressed. Pointed out in the constitutional consideration memos from Director Albrecht, Article 3, Section 25, this would be a concern with weighted voting. The vote required to pass a bill would, that provision of the Constitution would probably have to be amended to either be much clearer to expressly allow for it or much more ambiguous to leave kind of the unidentified possibility for that practice of weighted voting, because it does specifically state all the members elected to each house. Another section that wasn't mentioned in the memo, Article 3, Section 11, even constituting a quorum, the specific passage from the Constitution says a majority of each house shall constitute a quorum to do business. It's not clear under weighted voting whether that would be individual members or the weighted vote presence versus the weight of the total chamber. So again, when we get into weighted voting, not even taking on the considerations of you and your peers dealing with each other as equals, how that would all work out, I really see a lot of constitutional issues outside of specifically apportionment and redistricting. Another section of the Wyoming Constitution that brings up some concern right now, Article 3, Section 48, the state census that requires us to actually engage in reapportionment. The specific wording in that provision, the first budget session of the legislature following the federal census, the legislature shall reapportion its membership. And there's no clarifying language in that portion of the Constitution granting any relief from the mandate to do it or limiting it to specifically the decennial every 10 years census. Right now, we're facing a potentiality of having a mid-decade census. So if these constitutional concerns are not addressed through the process with whatever plan we come up with, if it's not fully considered across the Constitution, everything that's affected, we may be dealing with this sooner than we think, because our Constitution also states every time a federal census is done, regardless of when it's done, we will have a reapportionment of the legislature, or maybe a potential amendment clarifying that it's only during the results of the decennial census that we do reapportionment. I really hope that not getting on any specific plan for or against helps the committee adopt a posture that I'm really concerned about, which is the entirety of the Constitution being considered and bringing out language to address every issue for whatever plan we go forward with. The reality we're facing right now is that we could have another redistricting as soon as 2028. We may not be waiting till 2032 when the results of the 2030 census come in. So we really need to have those considerations, those proposals, and the constitutional amendments, I believe, ready to go for the 2026 general election so that they can be ratified in that election, because we don't know how soon we're going to be doing this again. The biggest problem I have with Article 3, Section 3 is the footnote. I understand it. I've read the law. I've read the legal precedent that's behind it. But what I really would like to see us do is get into a position where Wyoming does what the Wyoming Constitution says, and the Wyoming Constitution says what Wyoming does. Again, I'm not going to advocate for one plan over another on how we do it, but I think because each of you take an oath to your office saying, I will support and defend the Constitution of the United States and the Constitution of the state of Wyoming, it puts you in a little bit of peril when those two constitutions conflict and don't have clear language. We do have clear language. I believe it's Article 1, Section 20, maybe that reversed, but how the Constitution is amended. So if there is a legal challenge, if there is a court decision, I think that that should immediately trigger legislative action so that we can have our Constitution for the state of Wyoming fit the decisions of the court and the Constitution of the United States. So chiefly, I think that over the next few months, there needs to be a resolution to amend any of the articles of the Constitution, including Article 3, Section 3, Article 3, Section 11, 25, 48, whatever it be that is affected by the proposal and the intent going forward, so that there is some quantifiable good faith effort proven on the record, and future reapportionments can show that Wyoming does follow the state constitution and what it says, and the Constitution says clearly what Wyoming is going to do. I don't envy you guys in the task you're taking on, especially since there's a law that was passed that has a deadline date of December 1st, probably pushing you back to the next Corporations Committee meeting. So you really got maybe a month to figure this out, to satisfy the law and then bring it in front of Management Council or the entire legislature. So I know that's a tough job. I just really would like to see us take an effort to make sure whatever we're doing, it satisfies the intent and the requirements of the U.S. Constitution, and that may require something I'm not really fond of doing, making sure that the Wyoming Constitution is what we're doing. So beyond that, I don't know how many of you have been involved in redistricting before, other than the chairman and Senator Boner, but one of the things that will always remain, communities of interest, that will be a serious high-level consideration of any reapportionment effort. Those considerations affect things like Fremont County, native and tribal communities, the South Greeley area, and of course my district, the largest district in America outside of Alaska, the rural 16,500 square mile district. Sometimes those communities of interest can be of more importance than being within a county line, knowing that the population center of your county seat is going to do what they want and have the representation. So again, something I hope that the committee contemplates. I know that's been a posture of the redistricting efforts in the past. Honestly, we're lucky with our population that we only have to focus on state legislative redistricting and don't have to deal with the federal congressional redistricting. As we go into these conversations and the redistricting or reapportionment shows up whenever it does in the next few years or in 2032, remember, no one works harder on or during redistricting than your LSO staff. So always make sure you're being appreciative of them. Lots of late nights and administrative work. And I might be a little remiss in saying this, but it's something I learned from Chairman Case quite a few years ago. Do realize that it is statutorily, constitutionally, and procedurally easier and a more straightforward process to change a county boundary than it is to change a legislative district boundary once the reapportionment plan has been adopted and signed into law. So you might hear some people out there saying the answer could be to realign the county boundaries or merge some counties to better distribute population and therefore representation. I don't know realistically if that's in the cards, but functionally it's already a clear and executable process that does exist. So with all of that, especially that last part, I just think we need to be very careful and considerate with what we're doing. And when we as a state end up changing or adopting a new posture for redistricting to satisfy all these concerns, the ultimate goal is to make sure that our state constitution reflects the process that we actually engage in. So with that, Mr. Chairman, I will give you back your committee and stand for any questions.
Thank you very much, Mr. Correnti. Any questions for Mr. Correnti? Seeing none, thank you. So it's, we haven't really done anything yet. So we do have on the agenda the history and principles of redistricting by Mr. Obrecht. But I would certainly, given we've already given public comment ability to Secretary Gray and Mr. Correnti, if anybody would like to make a public comment at this time, of course you can, but you'll have plenty of opportunity later too, I promise you. We're going to take all public comment. Yes, sir. Yes, you do. I'm sorry, because other people are looking at this online, and the only way that you can be heard and seen is to push the mic and speak into that microphone, sir. Go. No, you'll get a green light and you go with that.
Mr. Chairman, my name is William Curley. I'm a Western County citizen. I just want to observe, these are preliminary matters, that as one of the authors, along with of sections 1 and 2 of SF 174, the reason that we focused in drafting those sections on apportionment provisions of the Wyoming Constitution is because we figured if we actually followed the state constitution and without amending it, maybe it needs to be amended, but if we actually followed it as it's now written, then the whole question of districting goes away. You don't have to redistrict anything. You just have to follow 3.3 that says the county lines are the district lines, leaving for consideration the issue of apportionment. And so this came to mind while listening to the previous speaker, and it'll come up again, but I just want to share with you that I think the proper concept here where the committee's concern is apportionment. Thank you.
Thank you. Questions for Mr. Curley? Questions for Mr. Curley? Thank you, Mr. Curley. Anybody else, or should we let the LSO give us their take on history and things? Not seeing anything right now, and there'll be plenty of time, you guys. So, Mr. Obrecht, would you take us to item 3, the history and principle of redistricting?
Yep, Mr. Chairman, under agenda item 3, Tamara Reveille, Legislative Counsel, and I provided the subcommittee with a memo on the history of legislative apportionment and redistricting in Wyoming. If we start on the bottom of page 2, since statehood until the 1960s, Article 3, Section 3 was followed in Wyoming with each county was given at least one representative and one senator. And then the extra representatives and senators were doled out in various mathematical formulas to try to give the larger counties more representation, more members in the legislature than the smaller counties. However, there was never any real equity among the population of those districts. And all of the members were elected at large from within those counties during that time. It all started to change in the 1960s. The federal court started to recognize that the Equal Protection Clause of the 14th Amendment required that in state legislatures, that districts had to have equity among the population to meet that equal protection standard guaranteed to the states through the 14th Amendment. So, the seminal case was Reynolds v. Sims, and that was based on Alabama reapportionment. And they had wildly different population among their legislative districts. The U.S. Supreme Court struck that plan down and said that that from henceforth, all state legislative districts had to have roughly equal population to satisfy the requirements of the 14th Amendment. And this followed shortly on the heels of congressional districts also needing to adhere very strictly, even more strictly than state legislative districts, to the population requirements. And as this jurisprudence progressed through the years, kind of a prima facie case of constitutionality for state legislative districts developed, where if in either the House or the Senate, if the smallest district was no more than 10% smaller than the largest district, then your plan was prima facie constitutional. If you had a bigger deviation than that, than 10%, then the state bore the burden of proving under a strict scrutiny review by the federal courts that you met a compelling state interest. And really hardly any state could ever accomplish that. I think it's very rare now that there are any districts that are greater than 10% deviation. Hawaii's one in their House, and it's based on islands. And we're another one, actually, after our last redistricting. We have got some Senate districts that are either close to or a little over 12% deviation, and that hasn't been challenged in court. And so, Mr. Chairman, that all came about for Wyoming starting in 1964. We actually had the Senate plan. The federal courts redrew the plan for the legislature, but then the legislature continued to redistrict along county lines following the 1970 census. In 1980, one of our plans even survived a direct challenge to the U.S. Supreme Court. It was a very narrow case, narrow holding based solely on Niobrara County. And then following the 1990 census, that redistricting or reapportionment plan was challenged in front of Federal District Court for Wyoming. Under Federal Voting Rights Act, those challenges are heard by a 3-judge panel of district court judges. So we had 2 district court judges and then our 10th Circuit judge sit on that case. And that is Gorin v. Carpin 1, where the court found in that case that the population deviations within that 1991 plan were too egregious and violated the Equal Protection Clause of the 14th Amendment. The court at that time gave the legislature the option to go back and reapportion based on the one man, one vote principle with not greater than 10% deviation. And if it didn't, the federal court threatened that it would redistrict for Wyoming. Wyoming did. The legislature come up with the plan. It was within that 10% deviation. However, the plaintiffs in the original case again sued, saying that plan actually needlessly split counties and needlessly split communities of interest. And the federal court in that case said, that's not for us to decide. That's purely a political question. And if it adheres to the equity of population, equal population, we won't disturb the state plan. And Mr. Chairman, in the 3 redistrictings following that, we have consistently redistrict with equal population within 10%, this last little minor blip being the exception. And we did, in the 2011, 2012 redistricting bill, we had a challenge to that in state court. And the plaintiff's position, among other issues in that case, was that the plan needlessly split counties, and the Wyoming legislature was required by the Wyoming Constitution to come up with a plan that, while it adhered to the population requirements of the 14th Amendment, did not split any more counties than necessary when developing that plan. The district court judge, state district court judge in Cheyenne said no. After Gorin and Reynolds and the other controlling federal cases, the Wyoming Constitution does not provide that county lines have to be followed within redistricting, and that there's no provision that says that you can't split county lines more than necessary during the redistricting process. So, Mr. Chairman, that brings us to today.
Thank you very much, Mr. Director. Questions from the committee for the director? Questions? Senator Bonner.
Thank you, Mr. Chairman. I wonder if we can maybe go in a little bit more detail, the differences between Brown versus Thompson, which is the 1983 case that was upheld our more or less county-based redistricting plan. And then only 10 years later, all of a sudden, a district court, federal district court can say, actually, that U.S. Supreme Court case is no longer relevant. We have to go by population. So it seems like a relatively short amount of time. And then there's also another element that I don't quite understand. How can the 10th Circuit, kind of ignore the U.S. Supreme Court? I understand, as you said, it's very narrow, but maybe a little bit more detail as to the interplay, what happened between the 1980 redistricting and 1990 to produce such wildly different outcomes.
Mr. Director.
Mr. Chairman and Senator Bonner, the Brown decision was so narrowly presented to the U.S. Supreme Court and based solely on the Niobrara County and not holistically into the whole plan at all, and whether that entire plan violated the equal protection provision in the 14th Amendment. The Supreme Court said that that the plaintiffs hadn't carried their burden of proving that that one of their fundamental rights were violated by that plan. So the Gorin defendants plaintiffs learned then that they needed to provide the entire plan, challenge the whole plan, not just what was perceived as maybe the more egregious provision of that plan. So that's what they did, and that's why the Brown decision wasn't controlling on the Gorin court.
Anybody else for the director? Anybody else? Mr. Director, Wyoming isn't the only state that's gone through this, of course, and there's been many other situations in other states. And could you give me a flavor or give us a flavor for how those have proceeded. Is it only Wyoming that's covered by the 14th Amendment, for example? Or how have challenges in other
You
states
bet.
proceeded?
Mr. Chairman, and I don't have universal knowledge on what happens with other states, but I know this, starting with Reynolds, which was the challenge to the Alabama apportionment plan. The one man, one vote principle, as announced in that case, has been applied to all state legislatures. And every state legislature, maybe outside of Hawaii, and maybe only because of the unique island situation there, have required that if their districts aren't within 10% of the population of smallest to largest, then they're subject to a strict scrutiny review and likely to be found unconstitutional under the 14th Amendment. And Mr. Chairman, I think to your point, what I do know is after Colorado and Idaho's reapportionment plans were challenged in the 1960s, they amended their constitution to provide essentially what the plaintiffs in the 2012 lawsuit were alleging that Wyoming should do. And that is that, that they will not split county lines and other communities of interest if it's possible not to while developing a rational plan.
Okay, thank you, Mr. Director. Anything else for the director? I just said we're going to do the committee first, and then we'll open it up to the public, promise. Anybody else on the committee? Anything else? And Mr. Director, just in terms of trends, have there been more recent cases that go in any other direction? I mean, we kind of have new courts and new things. Is there any indication that there's a new way of looking at things out there?
Mr. Chairman, when we prepare each, after each census for our redistricting to be able to give advice to whatever committee and the full legislature, we rely on the National Conference of State Legislatures and the information they put out. And then we do our own review of cases that may be developing in that area. And as far as any movement by the federal judiciary away from the 10% deviation or requirement for substantially equal population among districts, I'm not aware of.
Thank you, Mr. Director. All right, let's open it up to the public that may have questions. Ask them through the chair, and we'll see. It's just kind of be like stump the LSO director. We'll see what we can do. But you're welcome. But please use the microphone. Come on up. Yes, ma'am. Go ahead. Welcome. Introduce yourself and tell us what your question is.
Mr. Chairman, I'm Tricia Bauman here in Weston County. And I would like to first, after hearing stories from Senator Driscoll about reapportionment and people's hair on fire, I would like to thank you for providing this nice calm venue to discuss this and not being right after a census and taking the time to do research and talk to us. It's really appreciated.
Well, thank you. We look forward to coming here. We really did.
Good.
Me and Johnson, we're the only ones that lost our hair in that photo. Go ahead, Ms. Bauman.
I'm certainly not an attorney, and I'm absolutely not the director of the LSO, but I do have a question about page 4 of the LSO memorandum, Chairman.
Go ahead.
There's a quote in there that says the U.S. District Court for the District of Wyoming recognized that such an outcome, and they were speaking about a large legislature, would not provide for a functioning legislative system and directed the legislature to disregard the provisions of Article 3, Section 3. In my humble opinion, Chairman, the court in Gorin v. Carpin did not direct the Wyoming legislature to permanently disregard its state constitution and county line provision. The U.S. District Court for Wyoming found that the 1992 apportionment plan based strictly on county lines was unconstitutional under the U.S. Constitution. The court did not direct the legislature to disregard the state constitution. Instead, it ruled that when the state constitution provision conflicts with the federal, then the federal requirement must prevail under the supremacy clause. The court's language was about the practical impossibility of complying with both rules, given Wyoming's population distribution. A functioning legislative system in this context meant one that complies with both the U.S. Constitution's guarantee of equal representation and the state constitution. That'd be a functioning legislative system. The court, in my opinion, essentially said, you cannot follow your state constitution's county line rule if doing so violates the federal law. And it's my contention that there is the possibility, though I've found no one who likes it, of having a huge legislature. It's possible. It can be done. And so our federal constitution and our state constitution are not in direct conflict. So the supremacy clause is out. And I believe in Gorin v. Carpin, they were just talking about the 1992 where they went strictly by county lines. And so I just like to point that out.
Thank you very much, Ms. Bowman. I've thought about that a lot too. Certainly there is a way to reconcile the state constitution with the federal constitution in terms of having equal protection and also have county-based representation. But you'd have to start with Niobrara County, which is our smallest county. And it would be roughly, just say it's rough, I'll make up some numbers. Let's say it's roughly 2,000 people. I know it's a little bit bigger than that, but roughly. And you compare that to our largest county, which is Laramie County, and I'm going to throw a rough number out that it's 100,000 people now. So you would want Niobrara County to have potentially 2 representatives and 1 senator, or you could do it by having equal sizes. You could do 1 representative and 1 senator. But that would mean that Niobrara County, if they had 1 senator, then Laramie County would need to have 50 senators. And then it would work. And it would have to play out across the state. I'm not sure about the deviations within each county, but it would be, it would roughly come together. So I agree with you totally. I think the court, the actual wording was that that the legislature may disregard that section, realizing that this possibility of a very large legislature is workable. Mr. Director, I tried to give you time to think about that, and I was just waving my hand, so go ahead.
So Mr. Chairman, my reading of that provision in Gorin has always been that at the time in 1992, the way that the population was distributed across the Wyoming counties, you weren't going to be able to achieve substantially equal population based on county line apportionment. If in the future, though, you could, if more people moved to Niobrara County and it would work, or wherever we needed, then absolutely. But what the court was saying there, in my opinion, was you didn't have to, Wyoming legislature, you don't have to develop a plan with over 400 members, because that would be an unworkable legislative solution.
It's interesting they said that because New Hampshire has a legislature that's pretty much like that. But it's true. Back to you, Ms. Baumann, and appreciate your question. If you had any final comment.
I agree with you. I was going to bring up New Hampshire myself, and I think maybe what this goes down to is the footnote under Article 3, Section 3, that basically the common man on the street reads and says, oh, we can disregard the Constitution.
Yeah.
And I don't believe that's what that court case said. It said, you cannot follow your state's constitution county line rule if doing so results in a violation of federal law. So it doesn't say disregard it. That would be my point, sir.
Thank you very much for that. We do appreciate it. Who else would like to play Stump the Director? Mr. Curley? He's pretty smart. You keep working at it. Be sure and put the microphone on, Mr. Curley. Thank you.
Mr. Chairman, William Curley again. Thank you. I want to echo the comments Ms. Bell been with. Thank you all for the effort, the timing, the venue, the effort, and coming up here. On the most recent issue, it's absurd to claim that a federal court can direct a state to ignore, legislature to ignore its own constitution. And I point out to you, we've been all over this at the beginning of the matter today, but one of the findings made by the legislature in SF 0174 is that the two constitutions do not conflict as to apportionment provisions. I think Ms. Baumann.
Did your microphone go off, sir?
You don't have
Yeah.
to.
Sorry.
Yep, there you go.
Now, I think that language of the famous footnote saying, taken to mean you can disregard, comes from a federal judge saying, get the H out of my court, will you please? It's been here enough. Remember that to even get to that posture, the court had already declined once to rule, had pointed out that the legislature was the right body to be making these decisions, and then it came back to the going court because plaintiff sued again, saying, yep, the legislature took another shot, took another bite of the apple, but they didn't do it right. And so in that context, what you got is a federal judge saying, get out of my court, just satisfy my requirement under the 14th Amendment due process clause. But it's absurd.
Well, equal protection too.
Yes.
Keep going. I'm sorry. I didn't mean to
Yes, thank
interrupt
you. Okay, so the issue, the overall issue, and maybe question I have regarding the LSO 10 September 2025 memorandum is that it seems to preclude consideration of weighted voting. It seems to assume that the only way to comply with one man, one vote requirement is through equally populous districts. But of course, that is not the case. In fact, the author of the LSO memorandum cites in footnote 22, 74 Buffalo Law Review 1, revisiting weighted voting, and suggests that that would be a useful source to review on that issue. The author is Professor Norman Williams, Director of the Studies of Constitutional Law at up in Oregon, Willamette, I believe, University. And I recommend that. I maybe we'll be able to offer that into the record too.
Sure, of course you can.
Thank you. In that article, he makes the point that, and directly affects something said here today, the cases from the 60s, 62, 63, and 70, and Mr. Obrecht referred to them. There are cases from the 60s that say lower court cases, not Supreme Court cases, that say state legislatures can't do weighted voting. Now, I'm an author, along with Ms. Baumann, of a weighted voting plan that we're hoping you'll consider.
Mm-hmm.
The author of the article revisiting weighted voting points out that since those decisions, the Supreme Court of the United States declined to hear an appeal from a weighted voting case that in which the Second Circuit, so it's one step down from the Supreme Court, Second Circuit upheld the weighted voting. Now, this was at a New York County level. But the author makes the point that it's tough to be constitutional in one place and not constitutional in another.
Mhm.
And since that case, Krause, which is referenced in the article, there's a 1994 Second Circuit opinion upholding weighted voting again, also out of New York, where about half the counties to today have weighted voting. It is true that no state presently does have weighted voting, but that's not because it would violate the Constitution. Everyone says one man, one vote, and I'll just observe that the Wyoming Constitution 3.3 also requires apportionment in accordance with population. So this isn't a strictly federal thing.
Mhm.
Okay. Where was I going with that? Well, now I lost that. It's back to the apportionment. Okay, so none of the states have it, but I'm putting out for your consideration
Mhm.
and compliance. Having read that article, reference to footnote 22, that there are other ways to comply with one man, one vote. And what that means is, and it's correctly pointed out in the LSO memorandum, it means that the vote of any citizen is approximately equal in weight to that of any other citizen in the state. It doesn't mean the district populations are approximately equal. That's a way to accomplish
Mhm.
one man, one vote. But there's other ways. The plan that we've submitted, Ms. Bowden and I, would come up with a legislature roughly equivalent in size to what exists now. So that complies with the finding that perhaps it'd be better to keep the legislature small.
Mhm.
But it would be precluded from your consideration if the memorandum is taken to mean you can't do it.
Mhm.
Thank you.
Thank you.
But covered that, and that. And I think that covered it. Thank you, Mr. Chairman.
Okay, so I think we're going to give you a chance to present the weighted voting approach. It's our next agenda item. We could just jump in there, but I think that some people might still want to address the committee. So hold tight, Mr. Obrecht. I don't know if you want to say anything at this point. Hold tight, Mr. Curley. Let's see about other public comment on the LSO memorandum, and then we'll go into local proposals and different proposals that we have, including the weighted voting one, if that's acceptable. Who else would like to address the committee? Commissioner, how are you? Good to see you again. Welcome. Introduce yourself.
Thank you very much. My name is Marty Erman, and I had a prepared little speech, but I'm going to toss it to the wind because of the interesting way that we started this. So thank you very much for being here. I appreciate it very much for you to step within our boundaries, but I will throw a wrench right now. So in my investigation, and you know that I've been doing this for a long time, not as long as you have, I did keep most of my hair though.
It was a bad fire. Keep going. I'm
In
sorry.
Evelwell versus Abbott in 2016, the most revered and most wonderful couple of Supreme Court justices, Justice Thomas and Alito, had concurring opinions, and the case was based on using population versus eligible voters. So there was a conversation of that, and it went to the Supreme Court. They did rule in favor of the population. But in the
Could you get that mic more pointed at you?
Sure.
'Cause, I think everybody can hear you here, but
Sure, no problem.
some people actually watch this online.
Well, I would have been one of
They're-
them.
Thank you.
No problem, and thank you for reminding me. So, in a summation, what Justice Thomas' concurrence was, just in a summation, and I will have a quote, but Justice Thomas argued that there's no constitutional basis for the one person, one vote principle, stating that the Constitution leaves the choice of how to draw districts up to the states. Alito's concurrence was suggested that states are free to use different metric for apportionment if they choose, as long as it is not irrational. And I will give you a quote from Justice Thomas's concurrence. In my view, the majority has failed to provide a sound basis for the one person, one vote principle because no basis exists. The Constitution does not prescribe any one basis for apportionment within states. It instead leaves states significantly leeway in apportioning their own districts to equalize total population, to equalize the eligible voters, or to promote any other principle consistent with a Republican form of government. The majority should recognize the futility of choosing only one of these options. The Constitution leaves the choice to the people alone and not to this court. And so I just want to throw that wrench in there, that there is a crack in this whole thing.
Mhm.
And that if we can see a little light, and perhaps Wyoming can maybe put their finger in, or the door in the jar, a jar.
Something like that.
Maybe I should have something else. But I just would like us to think about that. And like I said, I appreciate you allowing us to speak in
It's-
Ottawa County.
It's a delight. And just to note, that was a minority opinion. Did they join together or did they write separate dissenting opinions, Alito and Thomas?
They did not write it. I could not find a dissenting opinion, just a concurring. with-
Okay. Separate. Okay, I understand what you're saying. Thank you very much.
Thank you.
Any questions, Senator Boner?
I'm terribly sorry. Could you say the name of that case again? I didn't
Sure,
quite.
and Mr.
ahead.
Chairman, let me spell it for you because I may be
That would-
pronouncing it incorrectly. It's EVENWEL Abbott,
Thank you.
2016. Thank you.
Thank you. Anybody else? Mr. Director, are you aware of that one? Care to comment? Go
Mr.
ahead.
Chairman, I think the commissioner accurately stated the concurring opinion in that case.
Okay, thank you very much. Who else would like to just address at this time about the LSO memo? We'll have more public comment later, I promise. This isn't your last chance. And I do see that we've got a dignitary that snuck into the side there. Speaker Nyman. Welcome, sir. How are you? Good to see you. I missed you before and I apologize for that. Okay, anybody else at this time? All right, let's go into the next subject, which was to listen to your proposals. So we're all ears. Mr. Curley, do you want to start? Ms. Bauman, you want to get up there and help? You guys have been burning the midnight oil, haven't you?
Go ahead.
Go ahead.
Oh, you want me to start?
Yeah.
Oh, you were supposed to start because I was nervous and then you were supposed to settle me down.
That's a man for you. I always say they're going to be there.
Yes. William Curley and I worked together trying to figure out how could we follow both constitutions, keep the legislature about the same size that it is now, and in addition, keep the power structure the same as it is now. So the voting strength on the floor from Laramie County right now is the same as the voting strength from Laramie County on the floor in our proposal. It does, as William alluded to, involve weighted voting. And we did put a handout on weighted voting if someone would like to look at that, but it basically reasserts what William discussed on revisiting weighted voting by Professor Williams. It's a quote from that. So that is in the record. We also did a second handout called Population of Legislative District and Voting Strength in the Legislature. And it's a short one. It says a direct relationship arises out of the different population sizes of Wyoming's legislative districts, counties, and the federal due process clause requirement that the vote of any citizen be approximately equal in weight of that of any other citizen. Currently, Wyoming districts are approximately equal in population, so their electeds have approximately equal voting strength in the legislature. To comply with both constitutions, we submit that constitutional districts, counties with substantially unequal populations have electeds who have substantially unequal voting power in the legislature. This assures that each county is a district and that each district's electeds reside within the county of those voters they represent, and that each citizen's vote is approximately equal in weight to that of every other citizen. So our proposal is called Population Adjusted Legislative Apportionment. And William, do you want me to go through the whole thing? Or do you want to?
No, wasn't gonna go through the whole thing,
Right, so
just the highlights
just the highlights. Okay.
that they can read it.
Okay, so this has been introduced into the record and copies provided. The introduction is basically what I just said. Page 1 is basically what I just said. So at the bottom of page 1 is definitions. We provided a voting unit. A House unit as 10,000 in population would receive a full vote. A Senate unit would be 40,000 in population would receive a full vote. These votes are scaled proportionally to the district's population, so therefore there would be 25% of a vote for 2,500 people in the House and 25% of a vote for 10,000 people in the Senate. It discusses equal participation, which according to the LSO memorandum was one reason that weighted voting was not accepted by the lower courts, was that voters or the legislators were disenfranchised in other areas that were considered non-voting legislative activities. In our proposal, all legislators have full right to participate in debates, bill sponsorship, committees, everything. So you are there fully participating, and the only time that you are weighted is in a floor vote. And then William and I spent several days trying to figure out a formula that you could use after every census. I don't need to probably go through that exact formula with you, but on page 2, number 4, what we came up with as a result of our formula is that in the House there would be 57.5 total weighted votes, 63 representatives. The largest district of Laramie would have 10 full votes, and the smallest district, Niobrara, would have 25% of 1 vote. Our point is the Niobrara citizens now have a person from their county sitting in Cheyenne, speaking for the commissioners of Niobrara, speaking for the courthouse of Niobrara, speaking for the citizens of Niobrara, but understandably can't put a lot of weight into the floor vote because their population is so small. In the Senate, it came to a conclusion of 14 total weighted votes by 27 senators. And I do have tables that show how that looks.
So, yes.
Number 5 is deviation. So people talk about the population equality, equal effective votes, and an allowable deviation of 10% in population. And William and I would like to look at a different type of deviation. So you would look at the percent of the state population that Niobrara has compared to the percent of vote they have on the floor and try to equal those out.
Okay. Okay, you want to add now? Okay,
Good with that.
do it.
Mr. Curley, go ahead.
Mr. Chairman, thank you. I think Mr. Coretti and perhaps others have concerns that a plan such as I'm putting forward would have issues with certain parts of the Wyoming Constitution. I want to make 2 points on that. One, Wyoming Supreme Court has not opined on weighted voting for the legislature. Be interesting to see what they said. Under a state constitutional issue, it's not a federal issue. It's for our court in Cheyenne. And I wouldn't jump the gun and just start presuming they're going to have a problem with this and a problem with that and a problem. Secondly, I'd like to, with the committee's permission, I will submit the full, it's just 2 pages, documentation of the email exchange between myself and Professor Williams. But I would like to point out that as part of his response, the following, and I think it bears directly on our plan's consideration. The memo, meaning the 10 September 25 LSO memo. The memo is right that lower federal courts struck down weighted voting schemes adopted by and for state legislature in the 60s in the wake of Reynolds v. Sims. But most of the article, meaning the professor's article, revisiting weighted voting, most of the article is devoted to discussing how some counties in New York continue to use weighted voting to this day, and how the U.S. Supreme Court upheld its use there. As the article explains, the federal court's rejection of weighted voting for the state legislature in the 60s cannot be reconciled with the subsequent cases after the 60s and early 70s, with the subsequent U.S. Supreme Court decision upholding its use for county commissioners, and that the reasons offered by the lower federal courts don't hold up today and wouldn't distinguish between state and county governments anyway. If Wyoming wants to return to a county-based apportionment system by adopting weighted voting, I do think it is constitutionally permissible. Though, in fairness, I would also add that the state is almost certainly going to be sued over it and have to defend it based on the arguments I made in my article. I have to concur with that. We live in a litigious society. We all know that. If it moves, it gets sued. So I think, so what I'm indicating is I think that the matter will get in court, not because this plan or other weighted voted plan is a bad plan, constitutionally defective, but because it simply will be challenged by somebody. Also, our plan, on page 1 at the bottom, indicates the definition for a unit for, in the House is 10,000, in the Senate 40,000. Now, where did those numbers come from? In one sense, they came out of thin air because they work. You plug those numbers into our formulas, you get a House and Senate of about the size you have now. Now, New Hampshire presently has a House of 400 members, representatives, and 24 senators. Their House unit is roughly 3,300. And their House unit, Senate unit is roughly 57,000, I think. So those numbers, there's nothing written in stone about them. We suggest they're good numbers to use to get a decent sized legislature that we're used to. Also, I ask you in considering weighted voting plans to always try to keep clear the difference, whose vote are we talking about? Are we talking about the vote of the citizen? Now, that's how the one man, one vote mantra is explained. And again, that language is set out in the LSO memorandum, the direct quote from the Sims decision. The weight of every voter is approximately equal to that of every other voter of the state. But there's also the vote of the elected people, the reps and the senators in the legislature. And sometimes, and I think once or twice in the LSO memorandum, there's a bit of possible confusion as to which we're actually talking about. On our plan, all voting plans are weighted in some sense or another. All of them. Even if I'm the king, I get all the votes and you get none, that's heavily weighted in my favor. They're all weighted. 3.3 and 14th Amendment require that the vote of every voter be approximately equal to that of every out, the weight of the vote. Now, if the populations are equal, roughly, then the electeds from those districts will have roughly the same voting power. Our plan suggests that we adhere to 3.3. We have therefore districts that are not equal in population, not even close to being equal in population. Their electeds then will not have approximately equal voting strength in the legislature. The voters in the different districts, counties, will have approximately equal weighted votes. And you accomplish that because the districts are unequal population by having unequal voting strength of the electeds in the legislature.
I'm with you.
Anything else?
No, I guess I just want to.
How's your microphone doing? There you go.
I guess I just want to reiterate that as we put this together, our goal was to keep the power structure of this plan as close as possible to the power structure that exists now. And there's case studies at the back of the proposal that I'm not going to go through them all with you. I would like to point out page 10 is the percent deviation in voting strength on the floor is a table C. And then there's an appendix with case studies. So I tried to take, right now you can't go by counties because the counties are split in the districts, but this is just a for instance, in the Senate, under our current system, Senator Steinmetz, Senator Driscoll, and the two senators in Campbell County, Troy McCowan and Eric Barlow, they currently have 4 votes out of 31 votes in the Senate. They each have a full vote. There's 31 senators.
Gotcha.
They have 4 votes in the Senate. So this is 12.9% of the vote. The Senate vote from those 4 senators have 12.9%. Under ours, if I go with the senator from Niobrara, the senator from Weston, the senator from Crook, the senator from Goshen, and the 2 senators from Campbell in our plan, and you put them all together, they would have 1.8 votes out of 14, and that's 12.86 of the vote on the floor. So 12.86 compared to 12.9 that you have now.
Good.
And that was our goal. Thank you.
I see that. Any questions, Mr. Co-Chairman?
Thank you. Thank you for the proposal. One question I had, you mentioned the vote on the floor. Do you anticipate that this would carry through in committee as well with the weighted vote coming out of committees?
Ms. Baumann?
No, sir. I think that would apply under the page 2 equal participation clause in our proposal. So the only weighted vote would be on the floor, but you would have full power in committee to do as you're doing now.
Keep going. And I might ask, how do you establish a quorum on the floor?
That point's already been touched on in the very beginning. You'd be looking at the, you'd have to rethink quorum in terms of percentage of vote strength
Mm-hmm.
and not physical bodies. Because again, you don't have the equal population districts.
Understand. So it's funny, and operationally, we sometimes have to establish a quorum kind of quick. The sergeant of arms usually does that. So they're like, they might be gavelled in, but we don't have enough people on the floor. So they're counting, and they're just looking at people and bodies and empty seats and trying to get people to fill them. Your way would be a little bit more complicated for the sergeant at arms or whoever does that, because it'd be more than just bodies. Keep going on this.
And I think without the advent of the computer age, we wouldn't be putting this plan forward for that reason.
Right.
But I believe the technological issues involved can be addressed so that it can be easily done quickly like that, because we'll begin to see, track, and display the weights for the people if the plan was adopted. May I add something?
You bet you can.
Just speaking as one of the authors of the plan and as a Wyoming voter, the issue of minority in our state, Indian tribes,
Mm-hmm.
just speaking for myself, there are federal reasons why maybe even my plan, even though I think it's great, couldn't be strictly adhered to, possibly, depending on how facts are on the ground and decisions are made on where to draw districts. But if you follow county lines, maybe it'll be an issue with tribes
Mm-hmm.
under federal law.
So that's actually my district. And
So I just wanted that caveat, even I am saying that you might not be able to achieve 1,000% perfection, because there's a couple of other things that don't affect the state that much, but maybe they do with the tribes.
I'm just thinking out loud. The federal issue is that is the only potentially, it's called a minority majority or majority minority. I might get it mixed,
Right.
but it's where a more minority population potentially makes up the majority of a legislative district. And so you need to pay particular attention to that, to not dilute their voting power. So what we did was create the Senate district and one House district that had the most Native American population possible. That is my district, actually. And so my district reaches into parts of Riverton, for example, that have a predominant Native American population. And it captures all the places on the reservation and elsewhere where Native American people live. And so that was done very, very deliberately. Now, if all of a sudden that representation were based on the county line, and then I presume that you'd be elected countywide, which everybody used to like a lot. They did like that. Then there's a potential for that Native American strength in their voting to be diluted. So, and you're the one that brought it up, but you made me think. That's what you're talking about, right? Microphone.
And I'm not, is what I'm talking about, Mr. Chairman. I'm not trying to predict the future that even my plan would have to be varied from, but possibly it could, for good federal reasons.
Okay.
I'm trying to tailor a Wyoming legal issue for Wyoming courts, comply with our state constitution as a finding in the legislation, a finding that's already been made, and as F-174, that the legislature exists because of the state constitution and the grant of power to it by the people through and it has no powers outside the grant. And its constitution says what to do to apportion. So perhaps the fundamental line here, to correct that you don't agree with this, is we'd like you to follow both constitutions. If you can't do that and have to amend the state constitution, which is one of the options mentioned in the LSO memorandum, then amend the state constitution and then follow it.
Okay, let's see if there are any more questions from the committee.
Thank you.
Committee? Senator Steinmetz, please.
Thank you, Mr. Chairman. And just since you brought that up with the tribes, and it raised another question for me, Mr. Crowley, and that is, or either one of you, whichever, but I'm just trying to wrap my mind around this proposal. So the bigger counties such as Sweetwater, Natrona, and Laramie would be decreasing in their number of representation. So how would you, if that's just based on county lines, then possibly the city, the urban population would be able to elect all three of the senators. And there, right now, it's divided so that some of the more rural areas like maybe Mills or some of the suburbs of Casper are able to elect maybe a more conservative or someone more aligned with their values. But if they're all at large in Natrona County, what is to prevent Casper from the urban center from electing all of the senators or representatives? Is there something in the proposal to address that?
Mr. Curley.
There is not something in the proposal to address that. It's a realistic issue. I'll mention that New Hampshire deals with that issue in part by using what they call flotarial districts. We've tried it in Wyoming. It's been that you can have districts that are themselves divided. And that may aid in addressing that issue. It would be a sin against the creator to set up districts that are run entirely by urban folk.
Does it really say that in the Bible? Wow.
It was in the margin of my book.
So if I can bridge her excellent point, you're saying that there might be room under the proposal to have sub-districts within counties.
Yes, the proposal would work with that method was adopted for use.
Okay. Is anybody else got questions? Are we doing okay?
Right.
I have one that's just looking, I don't see any other questions, and I think Mr. Obrecht, we gotta let him talk too sometime, but just in terms of the practicality, I get how this would work, and it's sort of, I can see how it's appealing. But let's go back to that example of Niobrara County, okay? Let's pretend like they ended up with one representative that had a quarter of a vote. That was just an example. I'm not meaning it, it's just an example. So are they really better off that way? Because then the rest of the legislators don't really pay attention to them, because there's only one person there that's beholden to Niobrara County, but they only get a quarter vote. So what happens when they go to Cheyenne, and how are they involved in making the things work or figuring out policy going forward? And how is Niobrara County better off that way rather than having different legislators, at least a legislator and a senator? And maybe if the county's split, they've got 2 senators and more. My point is, when you have more people that have a little piece of your county, you may not like it administratively because it's messy, But on the other hand, that's kind of a coalition that is working for your county on the right issue. And that can be very, very powerful. Help me with that, why that's worse than having, we're going to send John Smith to Cheyenne and he gets 1/4 of a vote. This is where I'm having trouble.
Mr. Chairman, I take that in two parts. One, if there are at times close votes in the legislature, are legislators willing to just ignore, blow off, be rude to, and guarantee the loss of all the quarter votes? Plus, you got other things working like civility, collegiality, interest, common interest in getting something done for the state. There's lots of reasons why it's not likely that intelligent legislators will just ignore somebody with a smaller weighted vote than they have. I think you've touched on it. I just echo what you already said. It makes all the difference in the world to have someone from your county that knows your school boards, knows your sanitation issues, knows your local hospital district issues, et cetera, talking for you and not having divided loyalties. That's got to be a hard job representing more than one. If you take in Wyoming, generally speaking, a county to be the basic community of interest, then it's got to be a hard job for a senator to represent more than one community of interest in Wyoming at the same time, equally well on all things.
I think those are good answers, Mr. Curley. I bemoan the loss of civility in the legislature and the factions that have developed more recently. I'm not sure how this really plays into that because unfortunately you really do count votes. And if you're trying to pass an amendment, you kind of are looking for the big bang for your bucks. Who do I have to go talk to? All right. And if I got people that have 10 times the vote of another person, I'm going to go talk to them. Ms. Baumann.
I would just like to point out on page 6 of our table that shows the weighted legislative votes. Niobrara does indeed only get 1/4 of a vote, and Hot Springs gets 1/2 of a vote. From there on up, Weston, Washakie, Crook, Platte, and Johnson all get 3/4 of a vote. And then everyone above that only gets 1 vote. So there's not one senator with 10 votes. The most one senator can have is 1 full vote.
Thank you for
So
that.
I think the discrepancy is maybe not as much as what's being portrayed.
Fair enough. Thank you. Mr. Co-Chairman.
So with the follow-up to your question, Chairman Case, so part of this to me is the voice of the community, having that representation. And so wouldn't you agree that in response to that 1/4 vote, you also have that voice on the floor? And more importantly, my other question about committee, if they're in a committee, they do receive that full vote and have that voice for the community in committee. And so that's where I would see the difference. I just wondered what your comment would be.
That's what our plan proposes. The weighted vote on the floor and all votes being weighted equal, so call it 1 unity in committee and for other purposes. But that's really up to the House. We put it that way in the proposal because we think that maximizes the whole point of sending someone from a small county with a weighted vote, less than unity. The very problem of not having all votes be unit votes I refer again to the professor's article that I'll submit. It's withstood federal constitutional challenge.
For counties, yeah.
Right, but the principle
Is
is
the
the
same.
same. If it's constitutional there,
Possibly I see that. I'm not sure, but I get your point. Yes.
thank you.
Thank you.
Thank you, Representative Knapp.
Senator Boner.
Thank you, Mr. Chairman. So following up on the concept of not having weighted votes in committee, I mean, would that not compromise the entire basis of what you're trying to achieve here, in that you're trying to have equal weight, one person, one vote, acknowledging that, but we just kind of ignore that in committee, and committees are important. You know, you can pass or kill legislation. So just a little bit more discussion on that. How does that construct retain the one person, one vote concept we're trying to attain here? Are you suggesting we change maybe how committees work, or, I mean, there's gotta be a little bit more discussion here, I think.
Mr. Curley.
Mr. Chairman, in response to the senator's point, I think he's, along with others, put his thumb exactly on the vein that's throbbing. That's the right place. But it is my take, and I'm only one person, make errors all the time, but the way I read the history of apportionment law, the issue really is, if you do weighted vote on the floor, full vote, equal vote in the committees, does that violate the due process and equal protection clause of the 14th Amendment? Case law says no. More modern case law than the cases from the 60s and early 70s that said there'd be a problem with that. That's the question I think you want to ask. Now, how you want to do it, though, if I was in the legislature, I'd have a vote, but I have a sense that a lot of this requires the common sense of the people that go to Cheyenne.
That's where you might have a problem.
I get to use this word finally. Are you telling me there's a dearth?
Well, I really do appreciate it. Any other questions from the committee? Senator Boner? You bet, absolutely.
Since we're talking about the importance of committee, our leadership team appoints committees and who's on them. How would you imagine leadership elections going in this? Would that be weighed too, or would it be one vote for every legislator?
Yeah. There you go.
I'm going to shoot off the cuff here and then turn the mic over to my co-partner. I think for leadership, if I was asked about that and part of the project, I would want equal input from everybody into leadership. In the way our legislature does business, leadership's so important. Talking about weight, there's the weight.
So it's not just leadership, but we've now kind of broken up into caucuses, which is, so we have, particular caucuses that lean in certain ways, or then you have particular party issues. So you have these kind of fractions already, or factions and fractions already, and I could see people that came from big counties that had full votes want to argue that they should be more powerful in electing the leadership of the legislature, or electing the caucus leader, and the reason is because I come from Casper and Joe comes from Cheyenne. I could certainly see that playing into the power plays that happen, and us by saying it won't happen, that will happen as power develops, and it will get paid attention to. Is that also kind of part of what you were thinking about, Senator Boner? Yes. Yeah. Go ahead, Mr. Curley.
Mr. Chairman, that is possibly an issue in I see you, if we were at a chessboard, looking ahead a few moves. And so possibly that is an issue that some discussion should be had on that constitutional amendment.
Mhm.
That would be the kind of thing that would be good to chisel in stone as far as it can be done legally
Mhm.
with not legislation.
Certainly, you could do it with respect to electing the leadership in the House and the Senate,
Yes.
but you couldn't change the makeup of the party caucuses or any other private caucus because they would have freedom of speech and association.
Yes, they've gotten some very favorable opinions on that, haven't they?
Yeah. Anyway, anybody else from the committee? I thought, Ms. Baumann, we'll go to you, and then I thought maybe we'd let Mr. Director opine on any, if he wishes to opine on any practical difficulties with a weighted plan. But Ms. Baumann, go ahead.
Thank you, Chairman. I won't take much more of your time, but this is an instance where I answered a question off the cuff and then later thought of a little bit more I'd like to say. So when you spoke about the Niobrara representative or senator having 25% of a vote,
Mm-hmm.
and I pointed out that Hot Springs then has half a vote, and then all those counties had 3/4 of a vote. I should have gone up a little farther and pointed out, for instance, Converse County gets 2 representatives. Each of those representative gets 0.75 of a vote. So a representative from Converse County, one representative of their 2 has the same vote as Weston County's person.
Mm-hmm.
So when we broke up okay, let me move up farther. Campbell County has 5 representatives. They get each 0.9 of a vote.
Mhm.
So it makes that discrepancy smaller as the individuals walking around the halls of our state house.
Mhm.
A representative from Campbell has 0.9 of a vote. A representative from Weston has 0.75 of a vote.
I see what you're saying.
Okay.
Do you think the people back home will get this? And, it's already confusing, the legislative districts. But then when we're down in Cheyenne and we have something coming up and the vote count is 13.25 will people understand that? And which way did our guy vote? And will they be confused? Mr. Curley?
If up on the board in the legislature is the figure needed for passage,
Yeah.
and then you watch the number come up, everybody will understand you fell short, you made it.
Okay. Chairman Knapp?
So in the break room, if I eat 0.9% of a cupcake, but I'm not, just,
You're not supposed to have cupcakes.
that was just on my mind.
With everybody's permission from the committee, Mr. Director, did you want to talk about any practical difficulties you can see? And I realize we're kind of putting you on the spot, and you can decline, but I know you won't.
Mr. Chairman, I do think there are very real practical difficulties associated with any weighted voting scheme in a state legislature. And you may alleviate one difficulty, which is committee voting, which I was trying to work my head around. And maybe that's the reason there's no legislature that does it right now, is committee voting. But I don't understand how you can, our Constitution says each bill has to go to committee. That's a constitutional requirement. And if you've got weighted voting on the floor, but not in committee,
Yeah.
I don't know how that's equal representation. And also the courts that have looked at this, and there's not been many because no legislature has it. So there's no law to challenge, no weighted voting to challenge. But they say that you can't really just boil down equal representation to the weight of voting of your representative. The representative from Niobrara County with 0.5% of the vote still gets the ear of the governor, still gets the ear of agency directors, still gets to question people on a witness stand. And so that's what those courts found was the violation, is that those smaller districts actually got overrepresented because of non-voting related issues. And maybe they got underrepresented in some ways in the voting issue then too. finally, I'd say that the Wyoming constitutional considerations are very real. And Oklahoma really found a provision of their constitution requiring bills to only be passed by a majority of all those members elected to, to be violated by a weighted voting scheme. So
And we essentially have the same thing.
we do. And we've got a bunch of other provisions that are either very close or questionable if weighted voting is considered too, from election of presiding officers to calling a special session to impeachment provisions to the 2/3 vote requirement for introduction in a special session, which is uniquely Wyoming.
Not a special session, but a budget session.
Sorry, for a budget, bill on introduction in a budget session. So anyway, Mr. Chairman, I don't know, certainly no federal court has said, to my knowledge, that you can't do this in Wyoming. And they certainly have upheld local, mainly East Coast entities doing it, townships, counties. Whether, and I think actually what the professor's case, what the Supreme Court was saying there is a local county commission or county board doesn't raise constitutional federal issues, but they've never held that in when a legislature using weighted voting has been presented to them. And I don't know if that question's ever been presented to the U.S. Supreme Court. To my knowledge, it hasn't been.
Thank you. Thank you very much, Mr. Director. Just thinking out loud, the problems of the committees, I think people don't think committees are very important, but they're an integral part of the process, and they are specified in the Constitution. A bill shall go to committee and be reported out. And, apparently we have one legislator that doesn't even think committees are important. They don't have to go during the summer, I guess. But they're amazingly powerful things. And since the committees are appointed by the presiding officer, and you could have lots of shenanigans there if the votes in the committee were different than the votes on the floor. Or you could have shenanigans if the votes were the same. If they were fractional votes, you could make sure that a committee leaned a specific way by putting people with philosophies and pairing them based on their votes in some cases. So it's complicated, but we'll keep going on this. Thank you very much. What else you guys got? Who would like to address us and the other proposals? We've got lots out there. Come on forward, please. Thank you both, Ms. Baumann, Mr. Curley. Thank you very much. Appreciate it. How do you do, ma'am?
Good, thank you. Mr. Chairman, Mr. Co-Chairman, members of the committee, LSO staff, thank you for being here tonight. This is an issue that's near and dear to my heart. And tonight we've been presented with at least 2 different proposals that follow both the Wyoming Constitution and the U.S. Constitution. And because each legislator has taken an oath to uphold the constitutions, I think we have a reasonable expectation that we should make a sincere effort to follow both constitutions. That being said, I also want to comment on what the court case that Commissioner Ertman said that kind of refers to any powers not reserved to the federal government is granted to the states. So and I also want to point out that I feel that it's a dangerous thing to say that we can disregard our Constitution. We're not talking about laws, we're talking about the Constitution. And I just feel that this is a guiding document. And if we are going to feel free to say that we can disregard one part, and I think that's a dangerous precedent to set.
Of course, we do have court coverage on this one.
I agree.
You get that right.
I agree, but we're talking court coverage, not, anyway, so that goes back to court cases such as Commissioner Ertman talked about. So what I would like to present is what we have come to call the Founders Plan. And it is a nice hybrid plan that you don't have a huge legislature, and you and also you have you don't have weighted voting. You have a whole person with a whole vote. And so this plan preserves the county boundaries as legislative districts while minimizing population disparities in compliance with the Wyoming Constitution and the federal legal standards. The Founders Plan uses formulas which ensure voting power deviations stay below 1.4 in the House, 1.4% in the House, and 3.8% in the Senate, and can be used regardless of any census results. Okay, this plan guarantees that each county has at least one representative and senator. The benefits is that you don't have to redistrict. That's already said. We follow the districts that are set up in the Constitution. It is just a apportionment, and it is used, and it used a fixed formula. So you apply the formula, and you don't have a lot of complaining, arguing, and you don't have the fractional voting, so you don't have to worry about whether you have a full or partial vote in the committees, or you all have one vote. This aligns with Wyoming's geographic and demographic needs and legal precedents. So anyway, so that's the benefits of this one. It doesn't, the deviations are a little bit greater than if you would use a weighted voting, but it still stays within limits. In the court case in 1973, held that deviations under 10% are presumptively constitutional for state legislative districts. Larger deviations require justifications by legitimate state interests, such as preserving political subdivisions and avoiding gerrymandering. So this is a basic plan that just has a formula that you apply to the counties in regards to the census.
And then if I could ask, where does the formula come from? Is it the formula from the Constitution?
I will let
Okay,
Tricia
you're getting to that. Okay.
discuss that.
And your name again, ma'am, please?
My name is Sue Morellis. I'm sorry.
Morellis?
Morellis, M-I-R-E-L-E-S.
M-I-R-E-L-E-S. Thank you, ma'am.
Mhm.
Ms. Bachman.
Yeah, Constitutional District Senator of Weston County.
Oh, okay. Thank you very much. Back to you, Ms. Baumann.
Thank you, Chairman. I didn't have a different hat to put on to sit with this second proposal. I just want one senator and one rep from every county, and the majority of the concerned citizens in Weston County are for this Founders Plan. That's what they like. And the formula, you asked where that came from. I made it up. And basically I set boundaries of, I want to keep the legislature about the same size as it is now. I want at least one senator and one representative from each county. What is the population of the state? What is the population of each county? How do I have to manipulate those numbers into a formula that's going to work? And so that I created this formula. The interesting thing about it is I checked it with, because this plan is similar to the 1990 plan, or after the 1990 census. And so I checked my results with the 1990. So back then, Laramie County had 10 reps. This plan has 11. And I think Converse County had 2 reps. This plan has 2 reps. It kind of came out about the same as that. And that's hence we named it the Founders Plan, because That's basically, back then, they were trying to go with the Constitution. We're looking at, so I know, I would guess that your brain is going into this 10% deviation in population. Definitely the deviation is greater in this plan. We looked at it at a different way, which I think should be presented to the court, and went with voting power on the floor.
Yeah.
And so there's a table in here. For instance, table 2, the Senate population study using a district deviation formula. If you look at that, Niobrara has 2,268 people in the last census. That's 0.39% of the state. And yeah, they get a senator. And there's a total of 29 senators total in the plan. So they have 1 out of 29 voting weight, which is 3.45% of the weight on the floor. And so they have 0.39% of the population, but they have 3.45% of weight on the floor. So we set sideboards where it can't be greater than 3.8, and they fall within that. Well, when I applied the formula then down below at the bottom to Laramie County, I only came up with them getting 3 senators. And so they have 17.35% of the population of Wyoming. They were only getting 10% of the vote on the floor. So there's a sideboard in the plan that says that's not doable. That's outside of the 3.8 sideboard. And so Laramie gets another senator due to that sideboard. So now they have 17.35% of the population of the state, and they have 13.8% of the vote on the floor, which is a deviation of 3.5% between their population and their floor vote. And I got this sideboard idea from Senator Driscoll. And whether you go with this proposal or the weighted proposal, or you come up with another proposal, if you do, I like Senator Driscoll's idea of having sideboards, because he said to me he feels like it's kind of a free-for-all. There's like not enough sideboards. It's a good word for whatever Wyoming chooses to do in the future. I think that's a good idea. But anyway, that's how this got done. That's the formula.
Okay. Any questions from the committee? I'm missing something here. So I must be missing something. So Niobrara gets 1 senator, right? So that senator represents, it's 2,200 or people.
Yes, sir.
And if you were to carry that same number out, then Laramie County ought to get 50 senators, 50. That would make their votes in Laramie County proportional to the votes in Niobrara County. But you said they don't get 50 senators. They get, how many? You said
4.
4. Well, how is that fair in any sense of the way? And how would that conform with the United States Constitution about having equal representation?
This plan relies on the sentence in the last page of the proposal, is the Founders Plan constitutional? And that's the sentence that Sue read, is larger deviations require justification by legitimate state interests.
Okay, so the legitimate interest you're trying to establish is that counties deserve this representation based on their boundaries of at least 1 representative and 1 senator.
Yes,
I
sir.
understand that completely. But how would Laramie County possibly ever agree that this is in their best interest, or Natrona County, or Campbell County, or my county, Fremont County? How could that be in their best interest at the same time?
I think it's always in the,
Go ahead. Yes, you betcha.
I think it's always in the best interest to follow the Constitution. I realize that they might not think that this is enough voting power, but I always think it's in the best interest of Wyoming for its legislators to follow the Constitution.
But we also have to follow the federal Constitution, right? Including the 14th Amendment. So show me how it follows that. I don't think it does.
I refer back to the court case that Commissioner Ertman referenced, that any powers not granted to the federal government are reserved to the states. And I think that the state should be allowed to set how we are going to set our boundaries.
Yeah, and just working with you on this, the post-Civil War amendments about voting power and disenfranchise of people, I mean, they came about to make sure that blacks who had been former slaves were going to be able to vote and have equal representation. And so it was a gigantic insertion of policy in state government, but it held and it happened. And so that kind of the same thing with regard to whether Cheyenne gets enough votes compared to Niobrara. Go ahead.
I would also like to bring up that at the federal level, every state, no matter how big or how small it is in size, it gets 2 senators.
It does, but you know why? Because it's in the U.S. Constitution. That is the great compromise that brought the small states and the big states together, and it is specifically enumerated in the federal Constitution. State legislatures aren't enumerated. Nothing but the 14th Amendment is there, loud and clear. Ms. Boffman.
I guess I would like to refer back to the Senate committees in Cheyenne. When people more intelligent than I and with a lot more power than I have expressed support for this plan, and they want to have it relitigated because the 14th Amendment does not use the words one man, one vote. That's a judicial interpretation.
It is.
And they would like to see that put forth through this Supreme Court, who the person who's been there the longest is Clarence Thomas from 1991.
Right.
The rest of them have never been involved in that issue from the Gorin case. And I guess it's a proposal for the committee to just consider
Sure.
if you want to go there.
Okay.
I might
Go ahead.
Mr. Chairman?
And then we'll go to Senator Boner. He's got a question.
I might say that I believe that Secretary Chuck Gray has expressed some support, and so at some point he might want to weigh in on that.
You bet. And we definitely keep him on he's definitely willing to come. We want him to come and talk to us. Senator Boner.
Yeah, thank you, Mr. Chairman. And I think, we're getting to the crux of the issue here is how do we, navigate our requirements under the federal Constitution here. And as somebody, I'll just share right now, when I started voting about 20 years ago, I was in Eastern Commerce County and my House district went all the way up to this community. And so I'm really proud of the work that we did this past session, deviating from that 10% requirement in I think a very logical way. For some folks in Sheridan County, I believe, that example sticks out in my mind where you don't have 200-300 people in a county that are just kind of lumped into the neighboring county to meet that exact standard. But I'm also, I'm going down the hallway going to the Senate. I see in the 80s, in particular, the 70s, they were combined counties in the Senate, at least. I think Congress and Niobrara worked together.
Yeah.
If we're going to give ourselves the best chance possible to win the court case, not just to have a court case, but to win it, would you consider something like that, where we do adhere to county boundaries, but we do have some combination to get a little bit closer to the current requirements, I guess?
That would make it easier, potentially. Ms. Baumann.
Chairman, I would support that as long as the state constitution is properly amended to say that.
There's another thing we could do. We could actually change the county boundaries. And we could change the county boundaries over time and then make sure they could evolve to be like the legislative districts, and they would follow your rule perfectly. They would have proportional representation, but we'd have to have fluid counties because population grows differently over time in Wyoming. What do you think of that one? Go ahead.
I think that would be just gerrymandering all over again. I don't think that would be a good idea, but it's possible. I haven't thought of all the possibilities or anything. And I would like to just reiterate what Tricia said, that let's follow the Wyoming Constitution, however we need to do that, whether it's combining two counties or whatever it is, but let's follow the Wyoming Constitution, whether we need to amend it or
Yeah.
make a plan of how to follow it.
So our oath is actually to uphold the Constitution of the United States and the Constitution of this state. So we have to do both. And we're having a hard time. And we actually, ever since Marbury versus Madison and later that case about the bank, I can't remember, that both established judicial review of the Constitution. That means that what the court says about the Constitution, you may not like it, but it turns out it's as important as what the words on the Constitution say. That's a big thing. So we have to follow the court cases too. So we're trying to follow them. Go ahead.
I was going to say that Mr. Chairman, the court cases can be overturned.
Sure.
The words on the Constitution can't be changed unless it's amended. So anyway, I don't know what the solution is, but there are a couple different plans out there. And so anyway,
Thank you. Anybody else on Senator Steinmetz?
Thank you, Mr. Chairman. And I just want to thank all of you guys for how much hard work you've put into this and giving us so much to think about. And we may not come up with an exact solution tonight, but getting this discussion in depth is really good. And maybe it's making you rethink some ideas too. So I really hope that we could even have another proposal that might look at amending the Constitution, like Senator Boner said. He and Senator Case have both dug into redistricting very deep because they were on this committee during redistricting. So they have knowledge that I don't have, quite frankly. I have been scouring everything you sent us all day long trying to understand it. So I really appreciate your explanations. And I would request next time, and as we move forward, maybe giving us visual maps as well as to what something would look like. So, you know, and comparing what our plan is now to a map that you might have, and take into account those communities of interest, like I was talking about with the previous proposal. How would that election look in Natrona County or in somewhere with multiple districts right now, where they're broken out into more rural and more urban communities? Because that is a real concern every time we do redistricting, because we don't want people to be overly, outweighted and aligned with someone else. And so it's an important metric for you guys to keep in mind as you go forward. But thank you so much for all of this hard work and formulas.
Which brings us to Mr. Curley holding a map. I can't hear you on the microphone. Maybe somebody else could hold a map and you could use the microphone. And the other case I was thinking of was McCullough versus Maryland, but it wasn't really on point to judicial review. It was more about the supremacy clause. But anyway, go ahead.
Mr. Chairman, as to the map, we have one. If you would appreciate more, let us know.
Mm-hmm.
Can we submit this, or I think you have, haven't you?
Well,
can we submit this?
We'll take it. The best thing we can do is we want to put all this on our website. And so I don't know how we can do that, but we can take a picture of that or something. We can do something with that. We'll figure that out.
Okay.
We'll take it. We're going to put it in his office, maybe.
Thank you on that. May I also just
Go ahead.
point out that in my experience in Wyoming, there's often a lot of people that dislike judicial review, but strongly believe the government should follow state constitution. In my view, they're the same baby in the same basket. If you only have and can have and need to have judicial review if you have a constitution that controls what the legislature does. They
I agree
rise and
with you,
fall
sir.
together.
Yeah, thank you, sir. So we're gonna take the map. I recognize some good names on that map. You bet. Can you grab her microphone if you want to hold it? Or however it works.
This is a map of just our local area, and though I personally am just as interested in the rights of the people in Niobrara and the people in Laramie as I am in Weston County when it comes to apportionment. I want that clear. This shows you what has happened to Weston County in the last districting. So the red lines are our representative districts. And you can see the red line goes through Weston County. And the red name there is Representative Nyman. God bless him, we love him. Representative Nyman also has Crook County, and he resides in Crook County. The bottom red box takes the bottom half of Weston County, which is represented by Representative Williams. God bless him, we love him, but he also has all of Niobrara and part of Goshen, and he lives in Niobrara. The green part at the top is a senatorial district, so Weston County again is cut in half, and Senator Driscoll has the top half of Weston, all of Crook, and part of Campbell, and he resides in Crook County. And then the bottom green part is Senator Steinmetz, and she has the bottom half of Weston, all of Niobrara, and a portion, and all of Goshen. And so none of them live in our county, and we respect them all, and we think they're doing the best they can. So this do not take this personally, but if Representative Williams and Representative Nyman vote against each other, Weston County, in my opinion, has no say in that vote. And then if Goshen County's best interest is one thing, and Niobrara's best interest is another thing, and Weston County's best interest is a third thing, Senator Steinmetz has to juggle that and figure out how to make a vote. Because counties have county seats, and those county seats need represented, Senator Chairman. We have elections. Our county clerk right now has to do an election for the north half, an election for the south half, and then it has to get merged with Crook County's election and part of Campbell's election. And we've found that can create a bit of an issue if one of the clerks does something wrong.
Okay.
I mean, there's so many issues. The money comes to the county seat. How does Senator Steinmetz, she's got to get money to 3 county seats, or do you count it as 2.5 county seats? You know what? We would just like to see, 3.
Yeah, your point is loud and clear.
Okay.
But my point is that Weston County has an advantage, and that they have 4 people polling for them if you play your cards right. And maybe it doesn't feel like it all the time, but I see 3 of the 4 are here tonight, right now. Now, if it was Joe Smith and he was your representative and we were in Lusk and he had 0.25 vote, do you think the rest of them would come and sit in on your county commission meeting? It works both ways. And as long as we think bigger in Wyoming than just our district and just our interest, it could work very well. But there you go. It's a good point. Thank you, Ms. Baumann.
I would just like to thank the chairman and everyone who traveled here for looking outside the box and looking at this calmly and trying to find a solution.
Thank you.
Thank you.
You've been very good to work with too. Thank you. We need more public comment. Anybody else want to address the committee? Do you have any more proposals? Yes, sir. I recognize this feller. His beard precedes him. Welcome. Good to see you.
Thank you, Mr. Chairman, committee. Appreciate you coming up here and looking at this issue. I guess I have a kind of a similar proposal to the one that was just presented. And my deal is even simpler, I guess, the way I see it, is basically every county gets the one senator and one representative for each county. And I know our Constitution, I didn't bring it up with me, but talks about
I got one.
talks about how the senators and representatives are apportioned. And I think it's not totally clear, but it does sound like they will change it according to population. And I mean, ideally, and it isn't spelled out one way or the other in the Wyoming Constitution, it would be similar to the federal Constitution, like it says there directly, each state will get 2. And I mean, I guess what I would see is, I know the one plan had a different proportion for senators and for representatives, but I would say, you know, if we just take and basically somewhere a number between 9,000 and 10,000, and any states that, or any counties that have less than, say, 10,000, they would get a representative. So, I mean, that would include Niobrara, clear up to almost Converse County. Then once you double that number, you would get 2, and so forth and so on as you go. And you would end up with numbers similar to what we have in our legislature now. And I guess the reason I come at it this way is I look at when our founders started this country, the big issue there was the small states, like you already mentioned, Senator Case. They came up with a compromise because they knew if they didn't have at least 2 senators voting, they would never get any say in what was happening in the country. And we're seeing the same thing in our state now, countywide. The small counties basically have no say in what happens in our state. And I go back to the Constitution. What's the first thing? We, the people. Our country's government starts with the grassroots. It starts with individual people. And so we've got to work from the ground up. We can't really come from the top down. And I know there's arguments that counties are just subdivisions of the state. But I think that needs to be challenged because in reality, each of us people makes up part of a county. And so if I'm not quite in the smallest county, I have land in the smallest county, Niobrara, but it's really uncomfortable to think that basically people in Niobrara have very little say in what happens in our state. I mean, one way or the other. I mean, they don't have it because they don't have their own representative and their own senator. And I think that's important. And it just goes back to that whole deal. And I mean, you know, we keep talking about the 14th Amendment, and I've been looking at it quite a bit here. And one thing that I got to looking at, and I don't know, sometimes I don't understand lawyers and judges because they don't always, you were talking about common sense earlier. Sometimes they seem to have very little common sense. But you look at the Section 2 of the 14th Amendment, and what it talks about, it's talking about representatives shall be apportioned among several states according to their respective numbers. It doesn't say representatives of states. This is talking about federal representatives.
It is. That part is.
And there's nothing in it that talks about county representatives. As I look at this.
But you have to read Section 1. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States.
Nor deny any person within its jurisdiction equal protection of the laws.
Equal protection. That means equal voting.
Well, the thing is
Is that the right piece, Mr. Director?
well, I would take exception to it because, I mean, granted, I'm not a lawyer,
Yeah.
but I feel that the way our country was set up, this Constitution was written and amended by common people just like yourself and me. And so it wasn't lawyers that were out there deciding what it was saying.
Mm-hmm.
It was common people. And the whole idea is protection for an area, for Maryland or Massachusetts or whatever the state might be. And I mean, the same thing applies in Wyoming, Weston County, Niobrara County, Fremont County. We should all get equal representation. We all have our one vote because we count everybody as if they haven't done something wrong, as one person that get their vote.
Right.
So I could choose my representative from Weston County to represent me in our legislature, or my senator. And so when I look at it, we get our one vote. And granted, it may not be equal, but sometimes equal isn't the best thing. And so anyway, I guess what I would say is I think we need to look at this a little bit beyond just the numbers all saying everybody has exactly the same weight when you go down to pass legislation, because even though we have that right now, we don't really have the same weight. I don't feel like I'm getting the same weight down in Cheyenne as people from Laramie County. I mean, because they have more people, and presently, Weston County, we've got 2 half representatives, if you want to say it that way, and 2 half senators, because, and like was already brought up, there can be conflicting views that they're having to look at and balance between counties.
Some of my people that vote for me say I'm a half-wit.
Well,
those are probably the ones that don't vote for me.
Yeah, there's some of us that get called that fairly often. So, but anyway,
Thank you.
That's the concerns I have, and I really appreciate you coming.
State your name for the record.
Oh, sorry, Alan Slagle from Weston County.
Former Representative Alan Slagle. It's good to see you. Now, can we talk just a little bit about comparing counties to the states in the U.S. Constitution?
Sure.
So the U.S. Constitution was drafted, as a result of the unsuccessful Articles of Confederation. And the states came together and they drafted it. And they had to figure out a basis to come together and form their government. And so the states, in some sense, are sovereign. They were 13 sovereign entities to form and draft this Constitution, and the first president being George Washington. The thing didn't get ratified until the Bill of Rights came along, but counties didn't get together to form the state. Counties have been peeled off from the state. We originally had 5 counties or 6 counties, I can't remember. And you've seen those old maps where the counties went all the way up. And we were part of Sweetwater County over in my neck of the woods. So counties don't have that same element of sovereignty that these states that formed the Constitution and the basis of our government has. That's different. Counties are political subdivisions. And in Wyoming, this says how you can change one county and make it 2, or take 2 and make it 1. You can't do that. There's nothing in this that says we can take Hawaii and Alaska and put them together and call them one state. So this is the element that's different. So counties, I honestly think we probably have too many counties because it's too difficult to fund smaller counties. It really is. But people like having them. Nebraska has gotten rid of, they had a proposal to get rid of like a quarter of their counties over time. There are counties that don't exist in Nebraska anymore as they haven't kept up in population. I'm not advocating for that, but I'm telling you, they're not magic like a state is. They are not, they don't enjoy the same political connection and sovereignty to the creation of the U.S. government. Your turn.
I guess I would agree that with that counties are formed. And I mean, and you brought it up. I mean, we start off with 5 counties, then as the population grew, they established more counties, divided out and became a county. And I mean, in a sense, that is a type of sovereignty when you gather together and form your county and incorporate or whatever you do to actually form that county. I mean, who collects the taxes? The county is the one that collects the taxes for the state. I mean, really, if we were just a true subdivision, the state should issue, we should have our Department of Revenue should collect taxes for all the counties, and we shouldn't even have to worry about having clerks. I mean, they would work for the revenue department. I mean, it'd be my opinion, but the way it's set up, we're set up as basically sovereign entities as counties. It looks to me like. Thank you.
Really good to see you, Alan. Mr. Cur we'll get the commissioner first, and then we'll go to Mr. Curley. So we got to have a plan to get out of here, you guys. You know, we said we wouldn't go any later than 9, and I want to respect that for everybody. So what we do with this, I don't really know. This committee's got to get together and make a recommendation back to the bigger corporations committee. And I don't think we're going to be able to debate that tonight. So we're going to have to maybe get together with Zoom and talk about possible recommendations, if any, to the committee. One recommendation is we can't see how to fix it. And that's just housekeeping. I'm telling you, just so I want to make sure that we do get out by 9. Commissioner, welcome. Keep going.
Mr. Chairman, I just wanted to push back on you.
Good.
Because I'm going to channel Justice Alito here based on this, what I brought up before.
Yes, ma'am.
And so let me quote
Okay.
for you. After much debate, Congress eventually settled on the compromise that now appears in the Section 2 of 14th Amendment. Under that provision, House seats are apportioned based on total population. But if a state wrongfully denies the right to vote a certain percentage of its population, its representation is supposed to be reduced proportionally. Enforcement of this remedy, however, is dependent on action by Congress. And regrettably, that remedy was never used during a long period. Voting rights were widely abridged. In light of the history of Article 1, Section 2 of the original Constitution, and Section 2 of the 14th Amendment,
I love this. You're doing
it is
great.
clear that the apportionment of seats in the House of Representatives was based in substantial part on the distribution of political power among states and not merely on some theory regarding the proper nature of representation. It is impossible to draw any clear constitutional command from this complex history.
Wow.
So, thank you.
I love that. Thank you very much for doing that.
Thank you.
You bet. Mr. Curley.
Mr. Chairman.
So before you get,
Yes.
is Charles Curley your brother?
Do I have to say that in public?
You can tell me later.
Yes, he is.
Okay.
I'm here to speak in favor of Mr. Slagle's plan,
Uh-huh.
as I understand it. Were I not less sanguine than he about the chances of prevailing in federal court on a question of federal constitutional law, I'd be a full supporter of his plan.
Mm-hmm.
But I have focused, as you're now aware, on trying to craft a Wyoming constitutional issue for Wyoming courts and Wyoming judges. But I will say, I'd like to say that the original decision saying back in 59, was it? Saying that, okay, federal court door is now open to apportionment challenges in the state was a bad decision. The Sims decision, the Reynolds v. Sims decision, I think Justice Clark and another justice, they concurred. I think he had a good point. The court, all it had to say was Alabama legislature is violating the 14th Amendment. It didn't have to say a word about one man, one vote, equal population districts, and all the rest of it. I think was, there was, I think there's a 6, 1 dissent, 2 concurrences. The dissent, I think, is even the better opinion. And I concur with the reading I've heard on why you want to look at both Article 1 and Article 2 of the 14th Amendment. I think Alito is right on that. That's the remedy. This modern one man, one vote stuff is all painted on by a liberal Warren court. And maybe it should be challenged, and maybe it would win on a challenge in the more conservative court. So I do like Alan's plan.
Okay. Thank you, Mr. Curley. Thanks a lot. Say hi to your brother.
Yes.
Yes, sir. Come on up. Yes, sir.
Mr. Chairman and committee. I appreciate you guys coming up here. We spent 2 nights in Cheyenne to talk to you. Now you get to spend a night up here to talk to us.
There you go.
I'm just a concerned citizen from Weston County. A lot has been said here tonight about the Constitution, and it is the supreme law. No judge or representative or Senate can change the Constitution federally or state, because it's we, the people, that have that power, and it's very clear. But when the founders founded this, they came out and said, we gave you a constitutional free republic as long as you can hold it.
It's a great quote.
Yep. And we are guaranteed by the federal Constitution to a republic form of government in the state of Wyoming. And that is what we have in Washington, D.C. It's not a democracy. They're trying to make the states run as a democracy, and we don't have to. The federal Constitution guarantees us a republic form of government, which is, we could go just to what Alan said, 2 senators. That's where you get your equal representation. The senator, then the Cheyenne can outvote us because they have more representatives, but we have equal say in the Senate. Okay, so that is protecting every man's vote. And it gets really complicated if the big counties don't like that we get what we get constitutionally, they can divide. And I've heard there's people in like Lands Creek wanting to, or KC wanting to split Natrona County because they get no representation. Casper runs that county, and they should divide. That's what we did when we left Crook County. We wanted our own representation. Sorry. And so that is constitutional. It's there. It's clear cut. But when you start talking weighting votes, you get into so many issues. There's no way that we can solve that. But getting back to the districts, we all agree the districts are set by the Constitution. That's county districts. Here's another problem. We had a problem here with an election. Chip Nyman, and I hope you don't mind me mentioning him, had an issue with his election. Okay, we in Weston County had an issue with our election. We went through one process, the next step now is if we want to complain about it, we have to be a registered voter in Weston County to file a complaint with the county attorney, because the state's attorney general said that's a county issue. Okay, now how does Mr. Nyman get justification in Weston County? Because he's not a citizen here, so he can't even bring the complaint against it because he's from Crook County. And it's just a mass menagerie of, and when I was in Cheyenne, I told you we sent 5 people down to put in a representative that didn't even live in the district that they put the representative in. That can't be. That's not American people. Let's just keep it simple. The heck with the torpedoes, full speed ahead. We have the Constitution that says that. Years ago, a group of us brought Sheriff Mack in here. 2 sheriffs out of Arizona challenged this constitutional carry permit deal. And they took it to the Supreme Court. We had dinner with him down here, and he came out with a 10th Amendment. And the sheriff that we had at that time was Bill Ware, and he was a 10th Amendment sheriff. And that 10th Amendment guarantees that the federal government can't tell us how to elect our representatives. That's a state issue. Nowhere did we give that away. And if they want to get nasty about it and they really want to uphold the Constitution and hold us to it, we have the right to succeed. It's in the Constitution.
I think you might be on thin ice there, a couple of those things, but keep going.
So I say stick to the constitutional grounds. Take it to the court. If somebody wants to go, take the 10th Amendment and see if they uphold it, because they're violating the 10th Amendment with the 14th Amendment by trying, and just the last election, and they tried to deal with Georgia's election. The Supreme Court goes, that's a Georgia issue. We can't touch that. So how are they touching ours? It was the wrong question asked in the right court to get the decision for the people that brought the lawsuit. And that's simple. And I just keep it simple. Let's stick to a republic form of government.
Mm-hmm.
That's all I have. Thank you.
And your name again, sir?
Danny Bao.
B-A.
B-A-U.
B-A-U. Thank you very much for your testimony, Mr. Brown. Who else would like to testify before the committee? Who else? Hey, here's a good young feller. Hello, Mr. Speaker. Welcome. Good to see you.
Good to see you too, Mr. Chairman. I haven't been called young fellow in quite a while, so thank you.
You're younger than me.
Well, what hasn't turned gray is falling out, so I guess we'll go.
I had that race.
Did you?
I lost both.
Well, I'm close behind you, so anyway. I don't have a plan. I can't come up here and try to give you guys any kind of a directive on what I think would work really well. I guess I'm up here just to tell you that I think that the whole premise of this, and I really appreciate Mr. Bao's testimony and the fact that I think really this boils down to, are we or are we not going to follow the Constitution? That was the question that was posed to me, is if we can't follow the Constitution, then let's change it so that we can. And I think that was the catalyst for me that really drove the narrative and why I did this and brought this. The piece of legislation that's come from the Senate, I didn't bother to worry too much about ours from the House because we knew we had mirror bills coming from both sides. And so the support of it was the fact that when I talked to my constituents here in my district, which I represent the northern half, their heart was, we want to follow our Constitution. And we want a Constitution that's been ratified by the people, and we want to be able to stand behind it, because when we swear to uphold that Constitution, we have a responsibility. And I think that was the thing that drove me in this, is that whether or not we can come up with some kind of a system, because as I sat back there and listened to it, when you started going on percentages and things like that, you know, your eyes start to roll, and you're just, even as speaker, my mind's trying to go through, and you mentioned it, Mr. Chairman, the logistics of that and the posturing and the maneuvering in that, I wouldn't want to touch that with a 10-foot pole. And so I think when I've got people in my community here and in my district that are saying, if we can't abide by the Constitution, then we need to change it so that we can. And if that would be, you know, something that everybody can get behind, then that's what it's about. But my whole job in this has been to represent the voices of the people that I represent. Whether or not I agree with this and try to do it or anything like that, I mean, there's a part of me that when you were talking about the fact that Weston County has basically 4 representatives, you know, but these folks want us to look at our Constitution and say, you know what, Weston County does not have a senator. They don't have a representative. And according to our state constitution, they should. So that's why we're doing this. And that's why I really appreciate all the efforts of these folks. I love these folks. These are, as you good guys all got a good view of tonight, these folks love this country and they love our Constitution. And these men that have gotten up here, and these ladies too, I don't know what their service has been, but these guys went and signed their name on the line to go and protect our Constitution. And a lot of folks did and couldn't come back to fight for it. They did it on the line. That's why I'm their representative, and that's why I'm up here to tell all of you, is that we have a responsibility to the people that we represent to do something about this. We can't just hope that this will go away and kind of have the idea that, well, it's in italics, but we don't really have to. But these folks want to see us write something down and draw a line in the sand, and then they can follow it. There is something in this, if I may, Mr. Chairman, that is a concern of mine, and that is that we are speedily moving toward a rural representation that is quickly disappearing. I did some math there early on when you start to look at some of the counties and their populations and their ability to be able to have a say in the amount of taxes that they pay and the responsibility that they have for the amount of surface area that they're responsible for. I think it takes 11 counties to equate to just the population. You can fact check me on this, but I think it's Gillette, Wyoming. 11 rural counties total, all voters in those counties cannot outvote just the simple town of Gillette, Wyoming. And so I think that's another part of this it's a side issue, but I think it's something that we better be very cognizant of, is this because of Wyoming's rural nature versus urban, that we are quickly moving toward a situation where as we redistrict, we can go in and take a portion of a city and quickly outnumber a lot of folks that when they have the chance to vote about a property tax increase, and it's going to affect them dramatically because of the sheer volume of land area for a school district or whatever, their voice has been greatly diminished. And so those are considerations as well. If Niobrara County had one senator, and Jefferson actually called the Senate the cooling tray. And that was the idea.
He used the word saucer, I think.
Oh, cooling saucer, the
Yeah.
cooling tray, cooling saucer. Okay. Anyway, yeah,
It's a great story.
yeah, it is. And I think what he was trying to get at is that, when you've got representation based on population, that's where those dollars are spent, but we send it to the Senate and we give even Wyoming 2 senators to be able to combat how many congressmen out of California or New York were able to put together and send to them. Suddenly a rural, low population area has to be brought to the table because we can't do this without you. I would love to see Niobrara County have that same authority and that same ability to slow this thing down and to say, you know what, if you don't take us into consideration, we will have something to say about whether or not this passes, even though we only have 2,268 people in our county. No different than Wyoming's less than 600,000 versus California or others. And I know it's in the Constitution, but those are the real concerns that the people that I talk to every day are worried about, is the fact that our voice is diminishing quickly. And if we don't look at this from a real thoughtful way, then pretty quick, a lot of the folks that are going to be carrying a lot of the labor, the weight of our tax base and everything like that, their voice is gone. So we've got to be wise about how we do this and how we respect those lines. And does the state of Wyoming have the guts to say, we're going to challenge the federal government on this because it's hurting us the way we're doing this. The way you want us to do this, ladies and gentlemen, is harming our state's ability to be able to even function. And so I think those are the underlying things that are in this that are so important. And that's why it's important to me, even though I don't live in and work in Weston County. And that's another part of this. I've listened a lot to the conversation tonight, and this has just been awesome. And I want to thank all of you guys for coming up here. This is what needs to happen. I don't get to Weston County enough. I don't. I live in the northern end of Crook County. That's just a fact. I'd love to be able to come down to every commissioner meeting and get chewed on or whatever, every school board meeting, and have the opportunity to have somebody chew my hind end for something I've done or they perceive that I've done or get accolades or whatever. I try to have as many town halls in this area as I possibly can. I try to be as available as I can. I took 3 phone calls from people in this county on my way down here. I remedied 2 of the situations by being able to have connections to send those people on to somebody that could actually answer their questions. But those are the kind of things that I deal with. It would be awesome for these folks to have their own representation. Somebody they rub shoulders with, and somebody when they walk in Deal's Supermarket in Upton, they're going to run into their representative. Right now, they've got a snowball's chance in a hot place that I'm going to be running into anybody in Deal's Supermarket. And that's the other part of this that is needing to be negotiated. And so all that to say this, thank you. Thank you for your time and for your effort in this, because this is no small feat. This has been a long time coming, and I told Danny Bow when he told me and we started down this road, you're going to get me killed. And he's tried very diligently to make sure that comes through. And so, but we're here, and you guys are hearing these conversations, and I appreciate the respect that you've shown my constituents, my people here in Weston County. I thank you for taking the time out of your busy schedules and making time to come here and put this together so that they can air their grievances and their concerns, and we can listen to real problems that these people are having, and hopefully at some point through this come up with a solution that'll preserve our state and preserve the rural nature of it and make sure that we continue to bring autonomy to the people of the state of Wyoming, where they have their voices heard in a way that actually is meaningful. So with that, without any questions, I will.
I think folks here are very fortunate to have your leadership, as we are in the legislature. So it's very privileged to have you come here, Mr. Speaker. I know that it feels like we need to save rural counties and that we have to preserve this representation. And it's very important. And it's important because there is a framework of the United States Constitution that might apply here. But it seems the other side of the coin is there will be people, Mr. Speaker, in the city of Gillette, city of Cheyenne, that will feel that they have lost some of their voting weight, their voting chutzpah, their power, and they will bring a lawsuit. The lawsuit will be filed. It could be on the same grounds as the Gore v. Carpin lawsuit as before. It could be very identical. Would it play out any differently? I'm not sure that it would. I don't think there's been that much change in the courts. And I think they have a legitimate gripe. If they don't have the representation that they had before, they've lost something, just like you feel you've lost something. So I don't have that answer. I do know, though, I hear about changing the Constitution. And we could make words in the Constitution fit whatever plan that we are going to do. We could make that happen. But the law, we propose constitutional amendments. We don't ratify them. The people of Wyoming ratify them. What happens if all those big voters in Gillette and the big block of voters in Cheyenne, the big block of voters in Casper, refuse to ratify your proposal? Then we've tried to change the Constitution and it's not ratified. That leaves us exactly where we are now. So I'm actually not even sure that changing the Constitution is a possibility that could work, because I don't think you have the votes. To you, Mr. Speaker.
Mr. Chairman, a statement that I learned when I was a very young man.
Yeah.
The answer is always no until you ask. So I think that's something that we have to propose that to the people of the state of Wyoming. And I think the people of the state of Wyoming realize how quickly things are changing. And you're right. I just gave you the example of how many rural counties it would take to equate to one town. But that is as good an example as I can think of, sir, as the gravity of what we're dealing with, because our ruralness is what many times makes us, I would say, makes us Wyoming. It's that tenacious, a willingness to never give up and to continue to fight, and no matter the odds, to always, always, always fight and never give up. And so I would just say that, sir, that we're going to say it's always no until we ask the people of the state of Wyoming.
You sounded like Winston Churchill there. Never give up, never give up, never give up. Nice to see you, Mr. Speaker. Safe travels home. Watch for. Oh, wait, I'm sorry. I didn't mean to cut. I didn't apologize. Senator Steinmetz.
Thank you, Mr. Chairman. And I couldn't agree with you more. And we've been looking at this. I mean, ever since I've been coming up here visiting with you guys, we've been talking about this, trying to figure this out, trying to figure a way that we could actually get it done. Not just talk about it, but actually get something done. So one of the things, as I've been poring over these proposals and doing research over the last few days, is one of the things we haven't talked about is an act of Congress. Because if there were an act of Congress, if our congressional delegation put something forward supporting our Constitution, then that overrides the court precedents because it's a law that was passed by Congress. And so what are your thoughts on possibly looking at that remedy?
Just for clarity, are you saying that a act of Congress could override the 14th Amendment?
Mr. Chairman, no, but it's
Okay.
a court interpretation of that part of it, so they could put some boards in to help remedy the situation with the states, because we do have the 10th Amendment as well.
I think it's an uphill battle, but let's hear from Speaker Nyman, and we might opine
Mr.
with
Chairman.
him. Go ahead.
Representatives or Senator Steinmetz. I mean, I think it's a very real possibility. And again, I'll go back to the idea, until you ask, the answer is always no. And so, I guess with the change in the dynamics of our national legislature right now, I think if there was ever one time that we could probably really float that and see what the feeling was out there, then I think right now is the time. And I think it would behoove us all to support that kind of mood, to ask the question, to pursue the options. And so, I mean, I know there's other times prior to this that would have probably not been worth the air it would have taken to bring that out. But I think right now, I think it would be something that could be broached, and I think it would be even thoughtful consideration, considering where we're at right now, in my opinion.
Can we just ask Mr. Director, and you can always say no, but on the generic ability of Congress to pass a law that impacts a court's interpretation of the United States Constitution?
Mr. Chairman, I suggested this in that memo, that a possible option could be an Article 5 convention, call for an Article 5 convention. Then we're changing the Constitution. And, you have a large number of states, whatever their political persuasion are, that are rural in nature. And of course, it's a heavy lift to get an Article 5 convention. It's never been done before. But that is one option to amend the Constitution to allow states to redistrict as they see fit.
With regards to Congress passing a law that affects a constitutional interpretation of a court, I'm having a hard time finding legislature tries to give court direction. They can look at this and look at that, but I'm having a hard time seeing where that would go anywhere.
Yeah, Mr. Chairman, I could conceive of some changes to like the Voting Rights Act that may help around the edges, but I don't know if federal legislation, I haven't thought about it enough to see whether it could really get to that issue, the core issue, or not.
Fair enough. Okay, good questions. Senator Boner.
Yeah, thank you, Mr. Chairman. And so in terms of, proposing solutions or potential solutions, I wonder if we could, we mentioned New Hampshire briefly. That's the one option where their house is literally, 200-300 people. And that is
400, I think.
Yeah, it's, so whatever it be here in Wyoming, you take the population of Wyoming divided by Niobrara County's population is probably 200 something, right? Would that be a possibility, Mr. Speaker? Obviously, it would completely change the House, and maybe that's made up. And of course, the New Hampshire Senate is only 20 some odd people, so maybe the House could take the lead there. But obviously, that would change the dynamic of the House quite a bit. But there is a example of how that does in fact work, and another state with a relatively small population. So, what did you think of that,
Mr. Speaker?
Mr. Chairman, you, Mr. Senator Boner, absolutely. I mean, it's working right now in that situation, but that would have to be something that people would have to decide if that's something that they wanted to pursue, and they would look at the costs that were going to be incurred with that. And then I'm sure that they would have to take that into consideration and say that that would be a way to do it. I mean, I've even heard a suggestion of get rid of the desks in the chamber and put a bench in there, and we all have to sit next to each other and make room for everybody and have it, that way. That was a suggestion that was actually made. So I don't know how that would work. But anyway, I guess to your point, and hopefully answer it, is absolutely that could work. And it would follow both the Constitution. It would allow following of our state and our federal Constitution.
Works.
And that would be certainly something that the people of the state of Wyoming could have that presented to them. And if they decided that they wanted to do that to provide the ability of the rural districts to have that kind of representation, then you open the idea and provide for the idea of a reduced size in the Senate, but definite reflection of the population and their vote and their weight of their vote in their Congress. And so that would be the House.
Go ahead, Senator Boner. I think that house size would be roughly 250 people.
Correct.
Go ahead, back to
And
you.
they just look at a picture of New Hampshire House is like the US House where they literally just have chairs all around. There's no desks, but there's a chair that you would sit in. And you know, I'm sure we can make it work if we wanted. Maybe your per diem would be a little different. I don't know. But to be clear, I'm not sure if that would take a constitutional amendment. That's something that the legislature could do without a constitutional amendment. And on that topic,
I think you're right. I
Yeah.
think we could, that is a conceivable thing. The nightmares to the director, and he may see other difficulties.
Well, Mr. Chairman, it wouldn't take a constitutional amendment except for Senator Boner's further point that you would have a smaller Senate.
Yeah, that part would.
Yeah, because the House can only be 3 times as big as the Senate under the current Constitution.
They could be the same size.
Yes, they can be this, it's got to be twice as big that the House does as the Senate, and it can't be more than 3 times.
So that means if the Senate were also proportionally, then so we have 250 people in the Senate, then we'd have 500 people in the House.
You know, Mr. Chairman, they told me that the reason I went to law school was so I didn't have to do math. And that's really the truth. But I tried to in this memo, and I think if you give Niobrara County 1 representative and you don't, or 1 senator, excuse me, and you don't make the districts any more than 10% bigger than what Niobrara County is, then you're looking at 213 members in the Senate.
That works.
And you've got to have at least double that under the current constitutional provision in the House. So at least 426 in the House.
Be some great parties.
Mr. Chairman.
Go ahead.
And
Mr.
see,
Speaker.
and that's the thing. I mean, those are the kind of discussions that would need to take place. That would be real dollars that would have to be figured out. Is that something that the people of the state of Wyoming would support? I don't know. I mean, I think there's some folks out there that would love to see that. I think there's some other folks that have real heartburn over the thought of growing government, you know, and so, but you're growing representation. But there again, that's for the people to decide. Let them decide that. If that's something that they want to do, then we as their representatives would follow their lead and listen to their will and do our very best to make sure that it's implemented. So.
Anybody else for the speaker? Thank you, Mr. Speaker.
Thank you, Mr. Chairman.
We're going to take as much public comment. We're trying to wrap it up, but Mr. Representative Williams, welcome.
Thank you, Chairman and members of the committee, and I'd like to repeat nothing that's been said tonight. The only thing I'd like to repeat is thank you. This is fantastic, and thanks for time, effort, hours, dollars, days of your life you'll never get back. We appreciate it, and thank you for being here.
Thank you. Thank you very much, Representative. All right, who's next? Come on up, Ms. Baumann.
This is just a question that popped into my head as all of you were speaking. When Wyoming became a state, did not Congress accept our Constitution as constitutional?
They did.
So then a judge overruled Congress in 1964?
In essence, go ahead, Mr. Director, bail me out of this.
Unfortunately, having written a lot of laws that get later found to be unconstitutional, it happens all the time. The courts find that that acts of legislation are unconstitutional. Under the American system of 3 branches of government, that's the role of the courts.
Ms.
Answered.
Baumann?
Thank you.
Thank you. Who's next?
Is that the right button?
You did well.
Okay, Mr. Chairman and committee members, my name is Carl Lacey. I am the constitutional representative for Weston County. I'd like to thank you for holding this meeting here at the Senior Center. I had some thoughts. I'm not near as elegant as our speaker nor some of you some of the other people here. But my thought is we need to follow the Constitution however we get there. We all, let's see. We need to return the people's right to at least one senator and one representative as a district according to county lines as defined in Article 3, Section 3 of the Wyoming State Constitution. That is my basic premise. That's all I'd like to say, and I thank you for this opportunity to say that.
Thank you, Mr. Lacy. We appreciate you too. Anybody else? Yes, sir. Welcome.
Just real quickly, my name is Dan Fouch, and somebody mentioned up grassroots earlier this evening. Well, let's keep in mind, it's the grassroots is why you guys are here tonight. It's the people in this room that's been working on this for months, some for years. So I do thank you so much for coming and listening to us.
We thank you. Thank you very much. You've all been very nice to us. We appreciate it. Anybody else? Mr. Bow.
An afterthought. You were
Yes.
talking about Cheyenne not getting their representation, and they have the population. But why should somebody that lives in an apartment in Cheyenne be able to run just as much of this state as a rancher out here that's got 5,000 acres that's paying probably 10 times the property tax that person in there is? Where's his representation? Because he don't have equal representation. He pays more than this guy, but this guy gets to decide what property tax he pays. So where's that equal representation there?
I don't know the answer, sir, but I expect we're going to get some emails on what you just said.
And thanks again for coming tonight. When I was at Cheyenne, I said the people wanted better, we deserve better, and I think we are doing better doing these. And I thank all of you again, and I'm sure I speak for this room. And Mr. Knapp has come down to some of our meetings. We're all Wyoming Knights. We're all in this boat. We either swim or sink.
Except for that guy in that apartment in Cheyenne.
That's right. Thank you.
Mr. Chairman, Sue Morales, I was wondering if there's going to be any other meetings of the subcommittee or if you're just going to meet with the joint committee? Or has that been decided?
I don't think it's been entirely decided. I suspect we'll have to have another meeting where we just kind of talk. But that meeting, we'd probably do it by Zoom, and that meeting would be open to the public. We will take public comment, but we probably, rather than have proposals, we just have to decide, what are we going to tell the committee? What is our report to the committee going to be? And I'm not really sure what it is, but we're not going to do that behind closed doors. We will do it in a meeting, and we have to, that sounds just like my ringtone, so I'm jerking around. It's okay. I suspect we'll have to have some kind of a subsequent housekeeping follow-up that we will make it available for you guys to listen to and provide public comment. Does that sound reasonable, committee? I don't know of another way. We're too tired now to write something up, and I think we got to think about it. I don't know. Does anybody want to speak again from Zoom land? Okay, well, let's hear from Mr. Corinthian. If Secretary of State Gray wishes to speak to us, of course he can. Mr. Corinthian.
Thank you, Mr. Chairman. Did a little more homework based on something that Director Ulbrich said. There are multiple provisions that I didn't mention in the Constitution if we're going to pursue a weighted voting. And right now I'm tracking no less than a dozen that would have to be addressed, including portions of Article 16 having to do with investment and loans. So if the proposers of these possibilities could draw up their constitutional amendments to address all of the Article 16, Section 6 and 12, all throughout Article 3, where it specifically states that the agreed by 2/3 of all the members of each of the two houses language can be addressed to make that weighted voting work the way they intend. I'm just not comfortable saying, oh, we'll figure it out, we'll interpret it, because the problem we're facing right now is based on an interpretation of clear language in the Constitution that's not being followed. Also, another thing that has popped up in my head is things like chamber rules, management council policy, joint rules, and then what we now have in split joint committee votes by chamber within the same joint committee. How are all those things affected by the weighted vote? I know we were told, hey, it doesn't affect the committees, but statutorily, committees are assigned with a certain amount of members from one chamber and another because of the number of people each chamber represents. So House committees tend to be bigger than Senate committees. So how are all of those, really this is just the nuts and bolts. I want to see how the machine could possibly run with that equal representation of population across committees when one chamber tends to have twice the amount of committee members. And if we could get an idea of how all that will be addressed and we can make it, a functional plan that doesn't run into the same Article 3, Section 3 problem we're having right now. It says this, but instead we do this. I would be very interested. Again, I'm not for or against any policy being proposed. I need to see how the machine's going to operate.
Thank you, Mr. Correnti. Any questions for Mr. Correnti? I think he does bring up a good point. If you have other things that you want to send us to flesh out your proposals, we probably should do that. I think we should take 2 or 3. See, when is the Corporations Committee meeting? So I think we should try to take 2 or 3 weeks to think about this and then come up with something to submit to the Corporations Committee along about mid-October. That's reasonable. I don't think we should do it right away, and I think that would give you time to submit more things if you wish. I'm not sure we're going to have any more in-person meetings, but we'll certainly do at least a Zoom. Mr. Secretary, welcome.
Yes,
You got out
thank
of your
you.
car and you're in front of the Capitol.
Yes. It was a long journey, but I got back. Sort
Good
of.
for you.
Thank you, Mr. Chairman. Well, I've been listening very intently, really appreciate the conversations, really appreciate all the citizens who testified there this evening. And this is a very important issue. Have talked about this with the citizens of Weston County and rural voters for some time, going back to the redistricting in 2022, which was quite contentious. I'll never forget. It was my last vote on the floor, actually, as a House member. And I did vote no. But, I think that this is a really important conversation. I think the weighted voting is something that needs to continue to be explored. I would ask the subcommittee to continue to explore it. I'm not saying that the proposal that was presented here this evening is the right formula, but I think it is an interesting starting point, an interesting point for us to consider. I think that, having the at-large elections in counties is something that could have some implications. I would want to think about that a little more on going back to at-large, but it's a starting point, what was proposed here. I would push back a little bit. I have some concerns on amending the state constitution. One of them, and the colloquy with Ms. Bauman was really, really interesting. And I think she did a really good job of laying out the precedent here. And one of the reasons why we would not want to amend the state constitution is if a court revisited this issue, which happens all the time. And I think with some of the changes in the composition of the federal judiciary, President Trump doing a great job of appointing in judges that are revisiting some of these issues, that this could be revisited down the line. I mean, these 60s and 70s decisions, many of them have been overturned. We could go down the list, and this is one of the many that could be revisited in the future. So if it is revisited and the state constitutional provision is no longer there, well, then it's no longer there. And I think one of the things that came out of that exchange was that the decision of the judge wasn't to ignore anything. It was that if they were in conflict, then which one would win out. And so I ultimately think amending the state constitution for that reason, I think it would be bad for rural Wyoming, bad for Wyoming as a whole. And I would push back a little bit on that. And open to continuing to talk about it. I know many individuals have taken that position as well, but I would push back a little bit on that one. I think the weighted voting needs to continue to be examined in terms of a solution that would comply with both the federal and state constitutions. And I will note, as Mr. Krenny noted in his testimony earlier tonight, his first round of testimony, that President Trump has issued an order for the Department of Commerce to carry out a new census. This is huge, Mr. Chairman. Chairman Case, this is a big deal. President is doing a great job. And, the amount of representation that is lost to non-citizens being included in the account, the distribution of federal funds, the way that is inappropriately done with the way these previous censuses have been handled and including non-citizens. It needs to be reversed, and President Trump is doing just that by ordering a new census. So I know this could very well come up very soon. And then, of course, we've got this great redistricting in Texas that they just did. And so this could be at the forefront. And so I'd appreciate the committee continuing to examine these issues and these proposals to have compliance with both the federal and state constitutions. Thank you.
Thank you very much, Mr. Secretary. We know it's late for you too, and we appreciate your diligence. Any questions from the committee? If not, we wish you well, sir. We're going to close the meeting now, and we appreciate you, Mr. Correnti, and everybody in this room, and the members, staff. Representative Johnson, thank you. And we wish you safe travels, everybody. And thank you all for coming.
Thank you, Mr. Chairman.